Thank you, Honorable Mr. Justice Witt. Caribbean Court of Justice, Original Jurisdiction, Case Management Conference in TTN OJ number 1 of 2021 between Rockhard Distribution Limited, Rockhard Distributors, Mutilal Ramhit and Sons Contracting Limited, and the State of Trinidad and Tobago and the Caribbean Community. This afternoon's three-member panel comprised their honors. Honorable Mr. Justice Witt, presiding judge.
Good afternoon, Counsel.
Honorable Mr. Justice Anderson.
Good afternoon, Counsel.
And Honorable Madam Justice Rajnath Lee.
Good afternoon, Counsel.
May we have the appearances, please? Thank you.
Good afternoon, Your Honors. May it please you. My name is Ian Benjamin, and I appear on behalf of the applicants. With me is, as counsel, Mr. Jagdeo Singh and Ms. Karina Singh. Can I apologize for the absence of Mr. Justin Phelps? He is otherwise engaged before another court at the moment that we speak, and we are all instructed by Ms. Nalini Jagnarang.
Your Honor, should it please you, Mrs. Deborah Peake leads me tomorrow Tuesday for the State of Trinidad and Tobago. We are instructed by Mr. Brent James and Ms. Radha Sukhdeo of the Chief State Solicitor's Department and Ms. Dina Isles, the Ministry of Trade and Industries Director Legal Services, is present as a representative of the state.
I think.
Yes. May it please your honors, I am Dr. Carlita Bab Schaefer, and I appear on behalf of the community, Caribbean community in this matter.
May it please you, your honors, Brenda Portland Reynolds, Solicitor General, and with me, Mr. Rennie Williams, holding a watch and brief on behalf of the Honorable Attorney General of St. Lucia.
And I think we have counsel representing TCL. Is that correct?
Judge, he was here. They were here early on when we did the testing. I'm not sure what is happening with them now. That's Mr. Jeremy and Mr. Ajuda. I think I see them asking to come in again. Let me just admit them. Thank you, Judge.
Can you hear me? We are having some technical issues.
Yes, I can hear you, but very weakly, but I hear that you have technical issues.
Okay, so I'm John Jeremy, and I am with Rafael Ajuda this afternoon for Trinidad Cement Limited.
Thank you. Okay, well, we are glad that you all have the right camera, and nobody looks like a cat, as happened to a Texan lawyer a few days ago. So you all like perfect people and counsel, and we are very happy for that. Before we get to the issue that occupies us today, which is interim measures, I have to tell Mr. Jeremy that, of course, we had an earlier session where we noticed that TCL had not been notified, and therefore we asked the registrar to do that. In principle, that would be enough to come as an interested party, but I see that you also asked to be an intervener. Now, what happened the first session was that the two defendants, which is Trinidad Tobago and CARICOM, already said that, okay, they would agree to special leave, and depending on the outcome of the interim measures, if I may summarize it that way, they would also agree with expedited procedure. So I take it, as an intervener, you will take the case as it stands. I take it that the intervention today is mainly aimed at whether or not interim measures should be imposed.
You're muted.
Yes, you have to unmute. Yeah.
Yes, as we understand it, that is indeed the position.
Okay.
We are here to object, obviously, to the grant of interim relief.
Okay. Okay, well, that is clear then. Mr. Benjamin, we have received your written submissions from both defendants and of TCL. It is your turn now to address them orally. Would half an hour be sufficient for you?
I shall do the best I can in that time that you'll let me.
Okay, I will not press you, but then you have an idea.
Yes, Your Honor. I'm going to work on the assumption that I'll be entitled to reply to what my learned friends might want to say in their oral answers.
Sure.
Yes. So, Your Honor,
Benjamin, are we not seeing you for a reason?
I'm sorry, my lady.
I said, are we not seeing you for a reason?
It's nothing that I can control. My video is on and my audio is on.
Oh, okay. Thank you.
I don't know if the technical people can intervene, but I certainly can see all of you.
Yes, but we would very much like to see you, Mr. Benjamin.
Yes.
So perhaps, as you say, somebody technical or more technical could intervene. There you are.
Right. Good afternoon, Your Honors. What is before you this afternoon is, of course, our application for interim measures. You have before you, of course, our application for special leave, in which the basis for the interim measures is summarized together with the draft originating application. On the last occasion, I indicated that subject to some limited amendments, the originating application would stand. Can I indicate now that since we were last before you, we have received from CARICOM the report that was prepared in connection with the decision taken to impose the 50% duty. So that is obviously something that we want to take account of in relation to the originating application. In further support of the application for interim measures, you will have two affidavits, a principal affidavit from Mr. Ryan Ramit, which would have been filed on the 21st of January, and a supplemental affidavit filed, I believe, on the 2nd of February. In response to those two affidavits, by way of evidence, there are affidavits from the state. They are filed on the 9th of February, the first from the Permanent Secretary, Ms. Aline Ovid, Permanent Secretary, Ministry of Trade and Industry, and a shorter affidavit from her counterpart at the Ministry of Finance. And then finally, the intervener has also filed an affidavit on the same date, sworn to by Monsieur Guillermo Rojo. You've already referred to the written submissions, so I don't propose to rehearse those. Can I dive straight in and indicate my little roadmap for the purpose of my submissions?
Sure.
I propose to tackle each of the bases that we seek to advance to demonstrate to this court's satisfaction that there is a prima facie case. After having done that, I will spend a little bit of time, to the extent that it's not already covered in the written submissions, on the question of urgency. And then finally, I shall turn to the question as to whether or not the grant of such interim measures is a just outcome or result for this court to adhere to. Going now to my first headline proposition, which is the prima facie bases that we seek to make out in order to persuade the court that interim measures ought to be granted so as to protect the interests of the applicants. They are as follows. First of all, I shall deal with consultation. Secondly, I shall deal with the issue of the interpretation and the vagaries of Article 83 of the RTC. Thirdly, I shall deal with the issue of disproportionality. Fourthly, I shall deal with the issue that COTED had no regard to the following international arrangements, the WTO, GATT, and the RTC regimes. And then I shall deal with, as a roundup, the issue of improper purpose. In so doing, I am broadly following the outline to be found in my written submissions. The applicants' contentions are as follows in relation to consultation. We asked the court to find, as a matter of a prima facie case, that in respect of consultation, it was not adequate or appropriate, nor was it in conformity with Article 26 of the RTC. In so doing, we will rely and invite the court's attention to this court's jurisprudence, which essentially identifies all community persons, such as the applicants, as persons who are entitled to protection, and they are entitled to protection in regard to their conduct of their business, the making of investments, the employment of persons, the conduct of trade, and of course, the paying of taxes. In relation to consultation, the applicants make the following complaint. We say specifically that the state party of Trinidad and Tobago and COTED failed to give the applicants any adequate notice of the proposed further suspension of the CET. We say secondly, and allied to that the state party and or COTED failed to ensure that the state party engage with the applicants in meaningful consultation when we were well known to be importers and distributors of cement into CARICOM. We say with respect that is not a statement capable of dispute, have regard to the many and multiple appearances of these parties before this court on previous occasions. So the essence of the complaint of inadequate consultation, inadequate notice, is that the state party and COTED did not provide us with an opportunity to engage meaningfully in deliberations, giving rise to the further suspension of the CET, as well as the imposition of the 50% duty. We have set out by way of evidence to be found at page 261, Exhibit RR11, an account taken from COTED of the efforts at consultation about which we complain. Can I invite your attention to pages 261, please? Do your honors have it? I'm obliged. This is the proposal issued by the government of Trinidad and Tobago for the suspension of the CET. If I invite your attention, first of all, to page 259 and 260, you will see that there is the background set out there, together with what it purports to be the justification. On pages 261 and 262, you have a summary of the Ministry of Trade and Industry's efforts at consultation. Can I take you to that? I am looking at inviting your attention to the very top of page 261 under the heading National Consultations. And it reads as follows. I'm on the first paragraph. I'll skip over the second and go directly to the third. The very first line reads that the MTI undertook consultations with the relevant stakeholders in Trinidad and Tobago, and by letters dated the 11th of September 2020, requested feedback from the Chamber of Commerce and the TTMA. By letter dated the 18th of September 2020, the MTI, that's the Ministry of Trade and Industry, the competent authority, sent letters to cement stakeholders, including the manufacturer, importers, and major distributors requesting feedback on the renewal of the suspension of the CET on other hydraulic cement. Going down to the third paragraph. The MTI identified that it got the following feedback from the TTMA, which contained a letter from TCL dated the 22nd of September 2020, which outlined a request to increase the rate of duty to 50% and provided information on the local market for cement, the main foreign supplier, initiatives being undertaken in other CARICOM countries, and other general information about the company. Pausing there, so that the ministry received correspondence from TCL identifying a request to increase the rate of duty to 50% and providing certain follow-up information. That letter was not shared nor given to the applicants. So that is as the 22nd of September 2020. Can I go now to the fifth paragraph? Multilateral Ramit and Sons Contracting Limited and Rockhard Distributors, the applicants, sent letters to the MTI of the following dates, the 23rd, the 25th, and the 29th of September and October the 6th. And those letters were sent from the same email address. The companies acknowledged that consultations had been initiated and requested disclosure of the rationale for which the MTI determined that a suspension of the CET was necessary. The companies indicated that this information was required to assist in fully understanding the circumstances by which the MTI was consulting on the suspension of the CET. So that you have there 1, 2, 3, 4 letters whereby the applicants were asking for information without having the benefit of being told in advance that any proposal with any degree of specificity was being considered. The summary of the consultation goes on to say, the companies indicated that this information was required to assist in fully understanding the circumstances by which the MTI was consulting on the suspension. And they also, reading the very last sentence, requested information on approvals from the WTO for Trinidad and Tobago to increase its tariff on other hydraulic cements. At the very bottom of the page, the MTI responded by the following letters, the 25th and 28th of September and the 5th and 9th of October. And they indicated as follows. In the 25th of September letter, the MTI indicated that as far as the request for the rationale was concerned, no decision had been made on the renewal of the CET, and as a result, there was no rationale to disclose. But pausing there, when I come to invite you to look at the text of the letter that came from TCL some 3 days before, they were advancing a rationale in support of a specific proposal to increase the CET to 50%, and none of that was brought to the attention of the applicants. Resuming on page 262, in the September 28th letter, the MTI acknowledged and granted a request for further time for the companies to adequately respond. In the October 5th letter, they provided information on the WTO notifications made with regard to the modification of the bound rate. And again, pausing there, they provided that information, but did not provide any further information in respect of the proposal to increase the rate to 50%. And then the very last comment in that paragraph, in the October 9th letter, the MTI detailed the WTO notification process and the justification presented to and accepted by COTED for the existing CET suspension. So again, pausing there, they were providing therefore only historical material. And in those circumstances, the ministry reiterated that no decision had been taken and that the MTI was in the process of reviewing the impact of the existing suspension and consulting with stakeholders to inform a way forward. The next paragraph records the fact that the sessions were rescheduled on at least, I think, 2 occasions. And then just picking it up in the middle of the paragraph, the circumstance advanced by the applicants was as follows: that they would not be able to meaningfully participate in the consultations, and they indicated this by letter dated, let me correct myself. The MTI indicated that via letter dated October 9th, 2020, that the consultations would be held on October the 15th, 2020, and those sessions were ultimately conducted on the 15th. The applicants did not participate. They did not attend the virtual stakeholder session because on no occasion in response to their written request were they provided with any of the information that they sought. And picking it up at the very last paragraph, they reaffirmed their position by email dated the 14th of October that they would require the requested information, i.e. information about a proposal, information about in support of that proposal, and information in justification in relation to those proposals in order to engage meaningfully in the consultations. And in those circumstances, having been deprived of that information, they were not able or willing to participate in the consultation exercise. Can I invite your attention in order to support the position taken by the applicants to Article 26 of the RTC, which is to be found summarized in the decision of this Honorable Court on at least 2 separate occasions. Can I invite your attention, first of all, to the 2009 decision? You will find the reference to Article 26 at page 505 or 514. If you could just let me know that you have it or have it to hand.
I think we wrote it ourselves, so.
I'm deeply obliged. May I proceed, Your Honor?
Sure.
Yes. At paragraph 64 of the judgment of this court, in that decision, you will see Article 26 is reproduced, and it identifies a consultative process. And its purpose is to enhance the decision-making process of the community. The Community Council, assisted by the Secretary General, shall, in collaboration with the competent authorities, establish and maintain an efficient system of consultations at the national and regional levels. 2, the system of consultation shall be structured to ensure that determinations of the organs of the Legal Affairs Committee are adequately informed by relevant information and inputs, and reinforced by consultations undertaken at successively lower levels of information. So just pausing there, there is therefore a statutory, if one could use the language, but really it's a treaty obligation to ensure that not only do the state entities engage in consultation, but that is to be supervised by CARICOM, and that is to ensure to ensure efficient decision making. If I can invite your attention to page 506 at paragraph 67, going on to 68. And skipping over 67, going straight to 68. Under Article 26, the Council is given the responsibility of establishing and maintaining an efficient system of consultation at the national and regional levels, the object being to enhance the decision-making process. So just pausing there. Meaningful consultation of necessity requires, at a minimum, the following: an indication of whatever proposals are being considered. And in this case, it matters not that there was a proposal coming from TCL with a great deal of specificity. There is no explanation, or we say there is no good reason why the contents of the letter of the 22nd of September 2020 should not have been brought to the attention of the applicants. And anything that was pertinent to its justification brought to the attention of the applicants so that they could meaningfully respond. Because in essence, what the applicants are complaining about, if you've invited us to engage in consultation, you clearly have a position that you want to consider because this consultation is taking place towards the end of 2020, but you haven't disclosed what that consultation is. And I can take you in this way, or rather I can invite your attention in this way to the evidence. There is nothing in the evidence from either of the permanent secretaries for the Ministry of Trade and Industry or that of the Ministry of Finance suggesting that the consultation material was ever brought to the attention of the applicants. And what we say about that is that as a matter of law and as a matter of fact, the applicants have established on this basis a prima facie ground for this court being able to intervene and to provide it with the protection that we seek by way of interim measures. Can I invite your attention to the permanent secretary's account at paragraphs 34 to 38. I'm inviting your attention respectfully to pages 832. I trust my Lord the President has it, and sorry, Your Honor the President has it, as well as the rest of the court. I'm specifically asking you to look at paragraphs 34 to 38, pages 832 to 834 of the bundle. That, as I said to you before, is it's the affidavit of Ms. Allen Ove. And you will see that there was nothing there. There was no obstacle to the disclosure by the ministry of its proposal, either before or after the consultation process had taken place, and or its rationale. You will see in the previous paragraphs, paragraphs 32 to 33, that is on page 831, that the permanent secretary refers to the fact that there was correspondence shared by the ministry with COTED under the CARICOM Secretariat. And this summarized that correspondence as follows, or rather, respectfully, Madam Permanent Secretary summarizes the correspondence as follows. It's in 4 subparagraphs at page 32, A, B, C, and D. I'm on page 31, going over to page 32. You will see that they refer to the letters in the same sequence, that at paragraph A, that there was a letter from MTI referring to a proposed suspension, but with no specifics. There was another letter of the 25th, again with no specifics. At paragraph B, the Permanent Secretary accepts that we complained that there was too short a notice. But just pausing there, there was, at that stage in the chronology, there was no reference to the fact that the applicants had asked for information. That is to be found buried in subparagraph C. There's a reference to the very same letters that I took you to, or that was summarized a moment ago. And there's an emphasis at paragraph C on the WTO position. And then it's only when you skip over the page to the very top of 832, I trust you have it, where it is said that we reiterated our request for disclosure of the information relied upon, and in the absence, contended we would not be able to meaningfully participate. And I just need to re-emphasize here that at this stage, we had no notion of any proposal, any specific proposal whatsoever. So secondly, we say that not only is this not consistent with Article 26, but it's not consistent with the revised procedures that are referred to by this honorable court in its judgment, in its 2020 judgment. That's 2020 CCJ 2. Can I invite your attention to specific paragraphs and page numbers of that judgment as follows? Can I invite your attention to page 538 of the electronic bundle? I'm confident that the court is very familiar with these revised procedures. This is a fairly recent decision of the court.
Yes, you can take that.
I'm deeply obliged. So on page 538 and 537, you will see, once you have it, the text of Article 83 is set out. And of course, that's the article in respect of which the operation of the CET and its suspension is provided for. I would invite your attention or invite you to pick it up at paragraphs 49 to 51. And I'm specifically relying on paragraph 51. May I proceed, Your Honor?
At which page of the record are you?
I'm sorry, page 539 of the electronic bundle. That's paragraphs 49 to 51, but I'm specifically relying on paragraph 51.
Okay.
Paragraph 51 sets out that Part C is for applications made to COTED pursuant to paragraphs D, E, F, G, or H. And it provides as follows. The court said that Part C provides one, first of all, clear guidelines for the processing of requests. And these are similar to guidelines in Part A and B. And that 3 steps are provided for. Step 1 requires, I'm on the 5th line, that the relevant member state include in its application information in support of the application, as well as alternatives considered to address the concerns of the member state. So we say that's absent from the application, and I'll make good that suggestion when we come to it. But much more importantly, that it must also consider the potential impact on an entity, industry, or importer. And we say that that too is absent. Step 2 says it places the responsibility on the Secretary General to circulate. And I can move now to step 3. Step 3, at the bottom of paragraph 51, requires that the competent authorities notify the relevant local entities of the request and provide to COTED any information relevant to that request. And as I invited your attention a moment ago, there is no material that we can find it anyway to be in the affidavits or in the other supporting material of either of the permanent secretaries that the applicants were notified of the request. So this is the 3rd limb of the consultation point. So the first limb being that you should give advance notice if you want to have consultation prior to making a decision. The second is that you must provide information in relation to what your thoughts are in order for that consultation to be meaningful. The third is that in any event, irrespective of the non-participation, that what did not happen in this case was that there was no notification to the applicants of the actual approach to COTED. And that is to be borne out by a letter dated the 14th of December, whereby we are writing, we haven't approached the court yet, but we are writing seeking to be told whether or not an application has been made and whether or not COTED has considered it. That is to be found at RR13, and the page references for that exhibit are 270 to 275. And if I can invite you just to make a note. And what we say in that letter is, we are unaware of any review of any sort of COTED. I'm reading from page 272, Your Honor. We are instructed that the state of Trinidad and Tobago has recently approached COTED for further suspension. So we know that the suspension application was decided upon over the period the 27th to the 29th of November. So as late as the 14th of December, we are in the dark. And we write to CARICOM seeking to get information, and we set out a series of detailed questions. And among those questions are as follows: whether the state of Trinidad and Tobago, in its application, if any, applied for an alteration or suspension of the revised CARICOM External Tariff. That's the first question. 2, when was the application made to COTED? 3, whether the state of Trinidad and Tobago communicated or informed or notified COTED of its intention to apply a tariff rate different from the tariff rate for that period? And if yes, the particulars and so on. So that is the third in a series of 7 questions, some of them with sub-questions, in which we say as late as the 14th of December, please tell us, please share with us the application. Now, by this time, unknown to us, CARICOM has already made a decision, as the record demonstrates. So those are my respectful submissions in respect of consultation and in reliance upon Articles 26 and Article 83. So we say by way of summary that there was no notification or notice to which we were entitled, irrespective of any argument that there might be from the other side or a trial as to the adequacy of consultation or our cooperation, or there was a suggestion in the state's submissions that we stymied the process. We consistently and repeatedly asked for information. None was forthcoming. In fact, we were led to believe that there was nothing that was being considered. Even at that stage, even when the consultation process is complete, we are told by the Permanent Secretary in the paragraphs I took you to that further studies were done. That's paragraphs 34 to 38. Further analyses were carried out. And as a result of those analyses, a certain approach was made to Cabinet. Even at that stage, we could have been told or could have been informed as to what the proposal was. That was not the case.
Mr. Benjamin, I think that point is clear.
I'm obliged.
This is your first half hour.
Yes.
So we have 3 more grounds to cover.
Yes. Let me move on. Yes. Article 83.
Before you move on, I wanted to just get something clear.
Yes.
You are saying, as I understand you, that the state and COTED breached your right of consultation.
Yes.
Now, and at this stage, of course, all you need to establish is a prima facie case.
Yes.
Assuming that you establish that prima facie case,
yes.
And indeed, assuming you establish your case at trial,
yes.
What is the remedy for that breach of consultation in your view?
We would ask that the decision be remitted back to COTED for its reconsideration.
Okay.
In other words,
so that you would wish then for COTED to have the benefit of your views on
yes.
the question of the. Okay, so so the most that you could get then would be just that, a remission of the matter to COTED for its reconsideration.
Yes.
With the benefit, as you said, of views that you could offer to COTED.
Yes.
Now, I'm just wondering how you reconcile that remedy, the maximum you could get, with what you're asking for here, which is in interim measures. I mean, if you're asking for a remedy which would nullify
yes.
the increase in the duty, I could follow you, but you're not asking for that. You're simply asking for an opportunity to be heard. Yes.
No, Your Honor, I am asking for both. You asked me a question that took me down the road of merits, and I was giving one answer. One of the reliefs that I seek is remission, but we also ask for a series of declarations.
Yes, Mr. Benjamin, if I understood what you were saying for the first half an hour, as the presiding judge said, you were concerned with consultation. And I was asking you, what is the remedy you would
yes.
expect to get in relation yes. to this consultation? Yes. And if I understood you correctly, you're not saying that the remedy was the vitiation of the increase in the CET. You're saying that the remedy is an opportunity for you to be properly consulted.
Your Honor, I'm sorry.
Yes, please go ahead. Yes.
No,
I think you understood the question.
Your Honor, so I simply wanted to clarify that I'm asking for both remedies. I've asked for both in my draft OA. I'm asking for both in my application for special leave. I seek both. In other words, I seek a setting aside, a declaration as to the illegality, the illegality of the decision vitiated by non-compliance at a minimum with Article 26 and the other provisions and the jurisprudence of this court in relation to consultation.
Yes, it does occur to me that you're asking for a lot on the basis of lack of consultation.
Yes.
I mean, yes. I would have thought the most you'd ask for is an opportunity to be consulted, but perhaps you have other grounds on which you will support these other requests. Yes.
Yes.
Okay.
I wouldn't want to be taken to limiting my case to consultation, as it is clear from my written submissions and my case.
Yes, it's just that you spent such a long time.
Consultation.
You just spent such a very long time on it, but when the maximum you could get is what I indicated. I was just concerned, but I'm with you, Mr. Benjamin. Yes.
That is by far the longest point. I will be able to take the other points much more briskly and much more succinctly. As my next point concerns the proper interpretation of Article 83. As you know, in our written submissions, we say that Article 83 and the court's jurisprudence requires that COTED be provided with accurate, relevant, and timely information when it considers the suspension of the tariff. And our contention is that the application to COTED ex facie failed to meet those requirements. And in particular, we can make a specific complaint that there is no material in the application linking the shortfall of government revenue, which in accordance to the evidence is to be measured in the billions of dollars, to the applicant's cement imports into the region. And there was no material, meaning there was nothing in the application that is in support of the suspension of the CET, nor any of the narrative that goes with it, nor is there any such material in the affidavit evidence that I've already referred to that seeks to make that connection between, on the one hand, the shortfall and the applicant's activity by way of importation and distribution. And so what we say is that the proper interpretation of Article 83 is to be derived from the Vienna Convention. It's well known. I hope I can be forgiven for not reciting what Article 31 of the Vienna Convention says. It's been referred to on many occasions by this court and relied upon, or at least on a couple of occasions relied upon. That is certainly the case in the 2020 decision that I just referred to. And what we say is that in the context that we argue for a proper interpretation of Article 83, and we say that when you come to consider the basis upon which we attack what is to be found in the application, that too is a basis for giving the applicants the relief that we seek. And in particular, can I just invite your attention, without asking to turn it back up, step 1, the same paragraph 51 of the revised procedures, again requires that CARICOM have before it information about the impact on importers. And we fall into that category, and there is no material before the court that they had the benefit of or made inquiries of us for the purpose of considering what would be the impact of a specific proposal in relation to the suspension of the CET and the increase in the duty.
I follow you, Mr. Benjamin. I just want to be clear. So you have moved away from consultation and you're now saying what? That the decision was irrational or unreasonable or?
Ultra vires.
It was ultra vires.
This is a vires argument on the proper interpretation of Article 83.
Okay.
Secondly, and further, what we say is that Article 83...
Mr. Benjamin, and when you properly interpret Article 83,
yes,
then what should we read?
You should read it. First of all, to quote Your Honor, one should have fidelity to the text. That's one. Secondly, in accordance with...
I know that, but
yeah, sorry.
When I have all that fidelity to the text and so forth, and I read Article 83, what am I reading then?
You are reading the fact that it is for the applicant to make out and for COTED to be satisfied that there is a direct causal connection between the broader economic complaints that has affected or been inflicted on everybody on the planet. On the one hand, shortfall in revenue and our activity. And what we say is that that is not made out. And no one attempts to. nor could anyone, in fact, make it out. Because, A, we say that's a common sense and sensible way of reading Article 83. But we say that given the relative scale...
Where in Article 83 are you?
I am, in particular, I am on those parts of Article 83. So that's 83.3.
3, yeah.
Yes, and you could pick it up, not A, not B, nor C, because they were not relied upon.
Right.
D, critical shortfall in government revenue being experienced by that member state, which is what I was on a moment ago.
Okay.
So there's D, then there's F, there's a need to support an industry in that member state. And G, they rely upon the suggestion that the product is of strategic importance to the economic development of the member state.
So are you saying they should not just say that, but they should bring material to show that that is so?
Yes. So
to what extent should they be able to prove it, or at least make it an acceptable proposition, or what is the state required to do?
All that the state is required to do is to make a clear causal connection between those criteria and the particular state of affairs. It's not good enough simply to repeat the excerpts from Article 83 in a rote fashion. Mm-hmm. That is what we are complaining about. What we are saying is that on the proper interpretation of Article 3.3, that is what happened in this case, and that the case in support of the application for the suspension of the CET has not been made out in a logical and causal fashion. That's what we say.
Yes, I had used words like irrational, and you had despised my use of that word. But you seem to be saying something similar. But please,
Your Honor, I stand corrected, and I apologize if I was not responding to the suggestion in a way that is helpful.
Okay, so
can I move on to my next point? That was Article 83. That's my various point.
Yes.
Yes. Proportionality is disproportionate. We make a complaint that when taken together, you have the following circumstances. You have A, a failure to consult. B, you have the existence of the 35% duty. D, you have the fact that COTED did not have accurate or reliable information in front of it. And C, continuing, that there was an application to increase the duty from 35% at the end of 2020 to 50%, as well as almost simultaneous or contemporaneously with that is you have the imposition of a quota upon the importers of cement into CARICOM. And we say that all of those matters taken together had a disproportionate and unlawful consequence as far as the decision is concerned. Now, it is perfectly true and correct that at the time that COTED took its decision on the 27th or 28th of November 2020, there had not yet been an announcement of the quota. That took place a few days later on the 3rd of December 2020. What we invite the court to infer, A, for the purpose of the prima facie case, and B, ultimately a trial, is that the state of Trinidad and Tobago had in its contemplation both measures at the same time, while they were engaging in consultations in relation to the increase in duty. They made no disclosure whatsoever, engaged in no consultations whatsoever over the same period of time in relation to the quota, and that the consequence of the quota has been and continues to be very destructive of the business of the applicants before you. As you know from the evidence, the quota that was announced with effect from the 1st of January 2021 is to reduce the total entitlement to the importation of cement of all kinds to 75,000 tons. And you know as well from the material before you that the applicants' share of that quota is 55,000 tons. And that is, of course, a fraction of what they imported, as it were, a couple of days or weeks before in the 2020 period. So
I
what
think
we
we're
say
following,
is,
yes, I think we're following the factual matrix very
Yes.
clearly. I just want to be clear. You said that the effect of the quota and the duty
yes,
was disproportionate and
Yes.
unlawful.
yes,
Was it unlawful because it was disproportionate?
it is unlawful for two separate reasons. Yeah, A, because it's disproportionate, it's the cumulative effect of the measures, and B, it is likely contrary to Article 83. There is jurisprudence from this court that suggests very strongly that the days of quantitative restrictions or quantitative measures is a thing of the past that precedes Article 83, and that the whole purpose of the CET and the ability to alter and or suspend the rate was so that quantitative restrictions would not be relied upon. And so that taken together, it is not only disproportionate, but certainly unlawful.
Well, yes, because I wasn't quite sure how you conjoin those two concepts, which seem to be quite different, because you could have a disproportionate effect on a business without the measure itself being unlawful.
Yes, that is
Now,
correct.
are you saying then that 83 prohibits the application of quantitative restrictive measures?
Article 83 certainly makes no mention of restrictive quantitative measures.
Yes.
And the jurisprudence of the court suggests, in reliance upon academic materials, that they form no part of the RTC. That is what the jurisprudence of this court suggests.
But does it suggest that COTED cannot authorize the imposition of quotas?
In these circumstances, there was nothing in Article 83 which permits it. So the answer is yes.
Oh, I thought that 83 gave COTED fairly plenary and wide powers to govern the operations of the CSME.
My respectful observation in relation to that comment, Your Honor, would be as follows. That plenary and wide powers would be relevant to the exercise of its discretion. But in the plane of international trade law, the ability to impose quantitative restrictions is something that you would have to find specific particular language for it to be able to support it. And in any event, in this case, you would be running up against...
I was Mr. Benjamin, sorry. I was looking at Article 15.
Yes.
Which spells out the role and function of COTED.
Yes.
And
I'm sorry.
That role and function are spelled out in very extensive language.
Yes. But can I make it clear, Your Honor, that no one, the applicants are not advancing a case that COTED imposed a quota. That's not what happened in this case. Okay. What happened in this case was that the state of Trinidad and Tobago did two things at the same time. Right. They contemplated and ultimately imposed a quota. And then secondly, they contemplated and had invited us to consultations in relation to the duty. They didn't do anything in relation to consultation in relation to the quota. That was not something that we were told about at all. Yes. The first time we heard about it was at the same time as everybody else on the 3rd of December 2020. Yeah. So I wouldn't want to be taken to trying to advance a case as to what is COTED can and cannot do.
I'm with you, yes. Now, are you saying then that the government of Trinidad and Tobago was not authorized or wasn't capable of imposing a quota, or just that you wanted notice and meaningful consultation before it was imposed?
In this case, we were entitled to advance notification.
Yeah.
The jurisprudence of the court is very clear that you do not take mercantile and business actors and subject them to ambush. You don't change the terms of their engagement overnight. And that's what happened in this case. In this case, we were told, again, without any notice or notification, on the 3rd of December, this is the circumstance in which you will be doing business 3 weeks from now. That's the evidence.
And I assume that your business arrangements would have antedated being so informed.
Absolutely, Your Honor. And of course, that would be a matter of common sense. And as it happens in this case, there is evidence before the court that we entered into contractual arrangements for the importation of cement as long ago as August of 2020 and have been seeking to effectuate them.
Yeah, which is something which has exercised me for a little while, because in the circumstance you're describing, I wonder whether we are reaching at the standard of consultation or of notice, which could be different. Yeah. Because you could be consulted and the same decision is taken anyway, and you're none the better off for it. So yes. I think in one of the judgments we had delivered, we had sort of very, perhaps timidly, referred to the idea that in the sort of circumstances we are now discussing, businesses ought to have notice so that they can arrange their affairs to deal with the impact of government decisions. But I'm not sure that you have developed your arguments in that particular way. It seems to me that the argument, as you have developed it, simply called for meaningful consultation, which of course in itself is quite a value.
Your Honor, I hope that I was doing both of those. In other words, my complaint in this respect has to do with the disproportionate cumulative effect of being deprived of any notice at all in relation to quota when that comes on top of the 50%. So that even on the assumption, let's assume that I'm wrong, that you're not with me in relation to consultation. And so I'm stuck with a 50% duty. I am still penalized in the way that I can conduct my business because I am constrained, even though my commercial arrangements must have been undertaken weeks and months in advance. I mean, and that's the point. Now, as far as COTED is concerned, what we did was we wrote to COTED and we drew it to their attention and we said, specifically, we know that you have made your decision, but you are under an obligation to keep the 50% duty or the level of duty under continuous review. You need to look at it again in light of the fact that there is a quota. So when you have to put the two things together. There is a quota which on the evidence lasts for a period of 36 months, and you have the 50% duty which on the evidence lasts for a period of 12 months. 1 month has already passed. So that when you take them together, you are dealing with a very much constrained period. And of course, it's in that circumstance that we've been asking for interim relief and of course, expedited measures. But the point is that those two very short time frames have an adverse and destructive impact on planning and on business preparation. And ultimately, they bring losses to bear upon a business entity, which we have given evidence about in our affidavit.
Mr. Benjamin, did we understand, at least am I understanding you right? Or did I hear at some stage that the matter of the quota imposed by Trinidad and Tobago is before the courts of Trinidad and Tobago?
That is correct, Millie.
How does that work? What are you seeking there?
In our judicial review, we are challenging the legality of the state to impose the quota under the trade ordinance, which is where they say they get the power from. So that's the circumstance. In these proceedings, there is no, as I made clear, I hope, to Your Honor, Judge Anderson, in these proceedings, there is no, this is a complaint directed at COTED, and there is no complaint that COTED had anything to do with the imposition of the quota, although we say respectfully that in accordance with the principles of judicial review that this court has outlined, that is something that they should have regard to as having an adverse impact upon us as an importer.
So are you suggesting though, Mr. Benjamin, that the fact that COTED has not reviewed their decision in the light of the fact that the quota has been imposed, that is in itself somehow ultra-virus, illegal, irrational, or is that part of your OA at all? Because
yes.
I see, okay.
Yes, so I'm sorry.
Because I seem to be, I didn't understand that to be the case at all.
Yes, Your Honor, we in fact wrote to CARICOM, drawing it to their attention and asking them to take it into account. The context of the exchange was as follows. You will remember on the last occasion, there was an exchange about the production of material. And by way of email correspondence, my learned friend, counsel for CARICOM, indicated that CARICOM would be convening for the purpose of considering its report on the 27th of January. Subsequently, we were told that reconvening would take place on the 4th of February. Prior to both of those dates, was the only point that I'm making, we asked CARICOM to consider the fact of the quota and its implications for us. And the way that we put it is, we invited them to consider what they would want to do or say about or in relation to the 50% duty in light of the quota being imposed on us. And specifically, we drew their attention to the fact that as of the 14th of January, the quota that was applicable to the applicants before you was 55,000 tons. So yes, Your Honor, that is the way that we sought to frame it. I hope that is a helpful response.
So when COTED took the decision, they didn't know anything about the quota.
That is correct, Your Honor.
So they can't be blamed for that.
They cannot be, yes, Your Honor. We are not, there is no criticism directed to COTED as to what they did, as to what they deliberated upon on the 27th of November, as far as the quota is concerned. That was something that was kept from them by the state of Trinidad and Tobago, as it was kept from us until the 3rd of December. On the 3rd of December, everybody knew.
But then you say, well, when they had an opportunity to reconsider it, they knew about the quota and they did not consider it?
All that I can, or the only comment that I can make is A, that COTED should reconsider it in any event, whether or not we invited them so to do. That's number one. And secondly, we expressly invited them to reconsider. And we did so by letter dated, I think it's the 31st of December. I'll give you the precise date in a minute.
And is it not possible that...
13th of December, I apologize.
Yes, is it then not possible that when they had reconsidered it, that they would have come to the conclusion it would not make any difference? Is that a possibility?
Absolutely.
Asking, huh?
Yeah, Your Honor, I am not running away from the fact that the jurisprudence of this court tries to confine itself to questions of process and legality. Yes, of course, they could have done so and so. But for me to enter into speculation as to what they would do one way or the other would not be appropriate. What I would look forward to is to CARICOM's engagement with us as importers, as is expressly contemplated by Article 26, Article 83, and the revised procedures.
Okay. Let's move on to the next one.
Yes, can I move on now to, and again, I want to take this very, very briefly or quickly, which has to do with the issue as to whether or not COTED was right in the way that it treated with Trinidad and Tobago's, how do I put it correctly, approach to the WTO bound rate. In 2019, the evidence, the record confirms that Trinidad and Tobago approached the WTO to be released from the bound rate applicable to cement. The court would have seen that we've put before you an affidavit of Matthew Nicely, and Mr. Nicely in his affidavit of opinion expresses the view that the reliance of Trinidad and Tobago pursuant to Article 18 of GATT was not lawful. And what we say about that is as follows. That was a point that we were making to Trinidad and Tobago repeatedly in correspondence, and they did not accept that. We say the following things. We say that in 2019, the representative from Grenada made the very same point. And we say that COTED ought to have had regard to that, not only in 2019, but again in 2020, because the applicability or the non-applicability of the bound rate is, to use language from a different context, a condition precedent for the suspension of the CET. In other words, it is a factor that needs to be satisfied in order for COTED to authorize the suspension of the CET and thereby authorize a further increase in the level of duty. And we say that that is a material and relevant consideration that by having regard to the fact that COTED did not take that point on board has the following impacts. We say that the practice of COTED and the practice of the state of Trinidad and Tobago is consistently to observe its WTO and GATT obligations, and that any indication that they have not been observed would be contrary to their practice, and we say contrary to what we would describe as a practice that is sufficiently well established to form part of customary international law on the level of international trade. We say further that it is not simply limited to the position of Grenada in 2019. The evidence before the court shows that COTED, in respect of the country of Haiti, took the very same position. I'm referring to RR6 exhibit. That's to be found at page 239 to 241, whereby Haiti at the time, and this would have been way back in 2015, raised the issue of the rebinding of its tariff rates that was introduced at the WTO. And what COTED undertook to do was to provide Haiti with technical support and help. And so I'm simply saying it's an illustration of COTED's adherence or fidelity to the observance of the WTO and GATT obligations. And then finally, for the purpose
I assume that these obligations you're talking about are not that of COTED, are they?
Sorry?
The obligations you're talking about, yes.
Yeah, I'm sorry, Your Honor, I didn't hear you clearly.
No, I was just wondering what obligations you're speaking about, because as far as I'm aware, COTED has no obligations under the WTO, does it?
Yeah, no. The obligations are the obligations of the individual states. Right. COTED provides support and technical assistance. Right. And in the course of its performing its functions, it consistently insists that states comply with its obligations. In other words, that Trinidad and Tobago comply with its obligations.
Okay.
That Barbados complies with its obligations.
Yeah. Time is going, Mr. Benjamin. Are you saying that you're of the view that Trinidad and Tobago did not comply with its WTO obligations?
Yes. Yes.
Now that may or may not be the case, but who makes that decision?
That is a matter for a state seeking to invoke the dispute resolution procedure provided for by WTO.
Right.
My argument does not go as far as suggesting that CARICOM and or COTED can do anything other than have regard to that obligation and have regard to whether or not it has been lawfully performed.
No, I'm just concerned. I'm sorry for interrupting, but I'm just concerned about our getting involved in an assessment as to whether a state has breached its obligations under the WTO, because as you so well know, the WTO no doubt has its own dispute resolution mechanisms.
Yes.
And they are the ones who speak authoritatively about whether there has been a breach of the WTO agreement. So obviously you are fully entitled to assert your belief that there has been a breach. But I'm not sure that we're in a position to rule on that, are we?
Your Honor, I'm not asking the court to rule in that way. What I'm asking the court to accept by way of my submission is that COTED and CARICOM properly have regard to whether or not, for the purpose of suspending or altering the CET, a country has or has not properly been released from the bound rate under WTO.
Yes, and that's exactly the point, Mr. Benjamin. I'm struggling to understand the tools that we're going to employ to decide whether there has been that release, that lawful release. I mean, surely to decide that question means interfacing with WTO law and with the machinery in WTO law, which decides whether there has been that release.
Your Honor, my point is much narrower. That as a matter of ordinary intercourse, COTED interfaces with WTO law on a daily basis. On a regular basis, when you come to consider its reports and its deliberations, it is constantly asking and considering whether or not a party has or has not done something that is required by its the fact that it's a member of the WTO, that it's a signatory to the GATT agreements, and so on. That is its standard bread and butter. There was nothing new about this. What we are talking about is the interface, on the one hand, between the RTC and the broader international trade arena, which is what WTO stands for, or what WTO represents. And that interface happens as a matter, as I said, of ongoing, everyday basis, and is evidenced in the documents that I've already invited your attention to. And so, just by way of anticipation.
So, for example, if Trinidad and Tobago was to take an action which prima facie
yes.
Reached its obligations in terms of its bound rate, for example, could that action be forgiven, to use a theological expression, by the other members of the WTO, and therefore Trinidad and Tobago would not be in breach? All I'm saying is that there seems to be a lot of mysteries to this WTO thing, which I'm not sure that we are sufficiently capable of navigating.
Your Honor, I understand and respect the as it were, the respect and the deference that the court wishes to play to WTO. Can I just make two small points, and then I'll move on to my next point. The two small points are as follows. In the classification decision before this honorable court, you had to consider quite expressly at a high level of generality the relationship between the RTC as a regional trade agreement and the WTO. Of course, you were specifically concerned with classification in that context. All that I'm saying is that this court's jurisprudence has already gone the step of recognizing that there's an interrelationship and working that relationship out. That step does not and did not entail you in that case, and I don't invite you to in this case, of usurping the function of a WTO tribunal. All that the court can do is to ensure that COTED and its constituent members of CARICOM countries, all of whom CSE members are members of the WTO, that they observe their obligations on the international plane for the purpose, and this is the important point of articulation, for the purpose of properly initiating and obtaining a suspension of the CET. That's really what I'm on. Okay. It is a preliminary step. And to the extent to which my little friends on the other side all cite cases from Portugal and Canada and Russia and so on, suggesting that I am going further than that and I'm seeking to ask the court to, as it were, usurp a WTO tribunal's function. I'm not doing that. And then the second small point that I wanted to make is that unique in this court's jurisprudence, individual entities such as the applicants before the court can come to it seeking relief. That can't happen before the WTO, and it can't happen.
Sorry, second small and final point, was that the language you used?
Penultimate. That's my second point on this issue. I only have one other matter that I'd like to trouble you with.
Very briefly, if you don't mind, please.
Yes. Well, can I do a wrap up in this way? We say that the evidence, as well as the allegations set out in the draft originating application supported by the application for special leave, disclose a pattern of conduct about which we are entitled to complain, and that therefore, we have made out a prima facie case that the true purpose is improper. That is to say, the true improper purpose of the 50% duty, taking in the context that I've already covered, is to eliminate our trade in cement with Turkey. Full stop. It's not for the purpose of supporting TCL. It's not for the purpose of protecting an industry. We say that when you look at the factual matrix of the series of events that have taken place over the last 3.5 to 4 years, that that's its true purpose. And we say that that's a triable issue that the court should consider.
Okay.
By way of two comments, just in relation to the just or unjustness of the remedies that we seek, what we say as follows. We say that the evidence discloses a capacity on the part of our clients who have been able to import cement into CARICOM over many years and to meet the duties even when they escalate to astronomical figures, and that they have the capacity, the financial capacity, as demonstrated by those facts, to back any undertaking. And that given the factual circumstance of a shipment that is of cement due into CARICOM within weeks, that would be this is an appropriate case, perhaps exceptionally, to provide the applicants with protection by way of the interim remedy that we seek. Unless I can assist you further, those are my respectful submissions.
Thank you.
Thank you. First defendant is Trinidad and Tobago. Ms. Peak.
Much obliged, Your Honors. I have to say, a lot of my learned friend submissions have taken us quite by surprise because we were having regard to the draft originating application to determine really and truly what is the case that they're seeking to advance. And a lot of my learned friend submissions in our respectful submission appear to deviate from the case that is on paper before you. But perhaps I could deal with those things as I go through what I propose to deal with. Your Honors, I think from the submissions filed on behalf of all of the respondents, and I include TCL for these purposes, I think that we have taken the court through all of the issues which have been pleaded, and that is the case that we've come to meet in relation to all of the issues, consultation, ultra vires, the decision being disproportionate, all of that we've dealt with them, supported by reputable authorities. A lot of the learned friend submissions today, in particular in relation to consultation, have not been supported respectfully by any authorities, including the authority of this court on consultation. And it seems to us that the applicants are asking the court to invoke common law principles of consultation and even going beyond what the common law recognizes as the requirements on the part of someone who is under an obligation to consult. In relation to that, can I say that we understand from the documents which have been filed that the consultation issue really relates to the revised procedures, and that is made clear in the application for leave, and you will see that at paragraph 82, which is at page 82 of the, or 22 of the record, and you will find it in the draft originating application at paragraph 83, page 57. And the learned friend took you to tab 2 of this bundle, which is the Rocker 2020 case, but he omitted to read paragraph 53 of the judgment, which is 540 of the record, which says, the revised procedures state that Part C will only become operative upon the entry into force of the protocol. Currently, the protocol has been signed by all parties to the RTC. It has not, however, been ratified by the member states and has therefore not formally entered into force. And it was consequent upon that finding that the court, in its deliberations, came to assist us all on what the obligation to consult entail, and we will take you to that. And it certainly is not, as my learned friend is trying to advance, that we were somehow under an obligation to disclose to every document that came into our possession from another party who had been consulted, or that we actually had to tell them when it is we were deciding to go to COTED that we intended to do so. That is not our understanding of how the court has developed the consultation obligation, but we will deal with that anon. In relation to WTO, again, what the learned friend said is not consistent with what we understand in the documents before you to be seen in relation to the WTO allegations. And in this regard, I could ask you to look at paragraph 94 of the application for leave, which is at page 26, which specifically talks about breach of the WTO obligations under GATT. And therefore, that is what he is saying that COTED should have had regard to, which is quite different from how he has articulated it in his oral submissions. But perhaps I should retreat into the approach that we would like to take. The first thing we want to draw to the attention of the court is this being an application for interim measures under Article 218. The first thing that the applicants need to establish is what is the justiciable right under community law that they are seeking to enforce, that they require interim measures to preserve pending the determination of the originating application. And this is supported by Rule 12.1.2a of the original jurisdiction rules, which require the application to establish prima facie the right in support of which the interim measure was sought. Now, my learned friend has made a lot of complaints, but he's failed respectfully to identify what right it is that the application for special leave or the draft originating application is seeking to enforce. In the written submissions at paragraph 7, you will see a big reference to business rights under the RTC. But respectfully, we say that what the applicant is seeking to do in these proceedings is to turn the CET, as it has been consistently construed by this court, on its head. And in this regard, we wish to refer the court to the statements of this court, I'm sure of which you're well familiar, in the TCL and CARICOM number 2 case 2009, which is a tab 1 of the applicant's bundle. And I just want to read for the court to remind the court how it has understood the CET at the community level. At 46, the court said, the CET is a fundamental pillar in the establishment of a Caribbean single market and economy. Its primary purpose is to encourage and promote the production of goods within CARICOM. It is but one of a range of measures identified by the member states as necessary in order to strengthen the productive sector and to accelerate the process towards making their exports internationally competitive. At 47, the court said, each of the 2 official publications, that is the 1992 and 1993 booklets, emphasizes the flexible and dynamic nature of the tariff and the need to cater in its application and further development for differences in economic circumstances of individual member states and changing conditions in the regional and international economic environment. At 49, COTED, replacing the Common Market Council, has the task of seeking to ensure that in the process of implementing the CET, the needs of regional industries are being met, recognizing at the same time that such industries must be geared towards greater production efficiency and competitiveness in international markets. In order to strengthen the productive sector within the community and to accelerate the process towards achieving increased export competitiveness, other supporting policy measures are to be put in place. At 51, where current regional production or immediate production potential from existing capacity exceeds 75% of regional demand for a particular product, imports of that product from outside the community are deemed to be competing, and regional producers of that product are normally assured a certain level of protection. Protective tariff rates are therefore established for commodities where the current level of community production of any commodity is sufficient to satisfy a minimum of 75% of regional demand for the commodity. Where regional production achieves the 75% benchmark, this circumstance ought automatically to trigger the establishment of a rate in the competing range for the particular commodity. The rate currently established, and this is 2009, the court is speaking, for extra-regional cement, 15%, lies at the low end of the rates usually prescribed for goods in the competing category. And 78, paragraph 78, the court said, COTED deliberations properly emphasize that their dealings in the market would follow the rule no matter what we source first from within. The court fully endorses this principle and considers that it should at all times be reflected in the actions of the member states. So this is this court, the competent authority, construing the CET. But this court did not say, understandably, that the primary object of the CET is to facilitate exports from third-party states outside of the CARICOM. That is not the main thrust of the CET. Yes, then you will find in the CET that there is to be trade with third-party states, but that is not the object of the CET. So when a learned friend talks about, this is the construction that you should put upon it, and put all of these provisions together and put primacy upon, trading with external third-party states such as Turkey, that is not what the CET provides for. And I bet the court that every member of CARICOM would be frankly surprised that that construction is being imposed or suggested to be imposed by this court. That is really, as we say, to turn the CET and the RTC on its head. So we say, contrary to the applicant's premise, and that is the whole premise of their case and their submissions, the purpose of the treaty and A40RI, the CET, is not to promote the importation of extra regional goods, in this case cement, at a rate of 0 to 5%. If anything, we see when establishing their businesses in 2015, which the applicants have repeatedly said to this court was to compete with TCL, and when they conducted their business feasibility studies, which we note have not been put before the court, the applicants would have reasonably and prudently, we say, informed themselves about the CET regime and understood that CARICOM's policy since 1992 and 1993, that's almost 20 years now, as determined by this court in 2009, that is 11 years now, has been consistently and quite properly, we submit, that where there is a regional producer satisfying more than 75% demand, imports of that product from outside the community are deemed to be competing. The regional producer, in this case TCL, is assured a certain level of protection. And further, that 15% is at the low end of the scale. So therefore, to suggest the applicants base their business models on the CET being no more than 5%, we say respectfully, is neither credible nor reasonable. Put simply, the applicants are not entitled under community law to ask the court to deny and or frustrate the legitimate expectation of the local manufacturer, TCL, to the protection which this court has held that the treaty and the CET affords to it. And that, in effect, is what the applicants are seeking to do. As this court has said in Rockhard Cement against the state of Barbados, which is tab 2 of our bundle, you find that at page 1737, and I quote, adherence to the rule of law required that the community not disappoint legitimate expectations it had created, unless an overriding public interest consideration so required, or the possibility of the adoption of a change in policy was reasonably foreseeable. As a national of this member state, that is the legitimate expectation that TCL is entitled to, and which it expects this court to protect. Thus, as CARICOM has correctly argued, the grant of the relief sought here, the interim measure, will not only frustrate TCL's legitimate expectation to protection, expressly and repeatedly recognized by this court, but it will expose CARICOM to legal action for that breach. The court doesn't wear blinkers. The court looks at the matter holistically and understands what are the implications of the orders being sought. In the only case, I remind the court, where this court has granted interim measures, which is TCL and Arawak against the state of Barbados, which is tab 3 of the applicant's bundle, the interim measures, this court will recall, were granted to give effect to the CET approved by COTED for regional cement. In that case, the applicants established a prima facie case of breach of the COTED sanctioned tariff on importation of extra regional cement. And of course, in that case, the court will recall that the state of Barbados did not oppose the application. And you will find that at paragraphs 18 and 37 of the judgment. I remind the court that before it set out the 4-pronged test for the grant of interim measures in paragraph 31, the court extracted the following helpful principles from the ICJ and ECJ cases. So in paragraph 20 of that judgment, the court said, the court ought to be satisfied that as a matter of urgency, the provisional measure ought to be taken as the harm to the right is so great that without provisional measures, it is going to disappear. or that the right would not have any genuine value when the judgment in favor of the applicant is rendered. Respectfully, we've looked at the applicant's papers, its written submissions, and we've heard my learned friend today, and it's impossible for them to discharge that burden. The court said at paragraph 21, the order is needed in order to avoid serious and irreparable harm to the applicant's interests, and there's a likelihood of success on the merit of the case. We say too, they fail there. The court said also in that paragraph, the burden is on that party to prove that it cannot wait for the outcome of the main proceedings without suffering harm of a serious and irreparable nature. They can't take that box either. The court also said the party seeking interim measures is required to prove the facts forming the basis of its claim that serious and irreparable damage is likely. They certainly haven't done that. So after reviewing those authorities at paragraph 30, the court made it clear that where Article 222 proceedings are initiated, the court will, where it considers it appropriate, grant interim relief only after, and this is the court's language, considering all relevant circumstances, including the balancing of the interests, both legal and factual, of all persons directly affected by any order for interim measures. So the court itself recognized that it is required to balance the interests. On the one hand, and let's go to this case, TCL, which is on the undisputed evidence, invested millions of US dollars in establishing and developing its cement manufacturing plant. It sources more than 90% of its raw materials locally, employs hundreds of nationals, is a net earner of foreign exchange, thus contributed to Trinidad and Tobago's GDP. We look at the state next, needing to raise taxes to meet the burgeoning expenditure of the country in the face of a budget deficit of $16.7 billion, which from recent indications yesterday is growing. And some of your honors might have read one of the newspapers today, where the headline, no surprise to anyone, is living in debt, DEBT. At the same time, the state of Trinidad and Tobago is supporting the local cement industry, which is one of the key pillars of the non-energy sector. It is of strategic importance to the economic development of the country, is employing nationals.
Sorry, Mrs. Speak, with respect, aren't you going to the merits here? Because all of those ills that you are describing for us so well are ills which would attend a decision against you, a final decision against you. All that the applicants are asking for, as I apprehend it, is for the proposed CET or the CET not to go into effect until trial. And if at trial they fail, they have said they will make good the loss to the state. So I do understand the problem of the macroeconomic situation. Indeed, I understand the microeconomic situation as well. But the point I'm making is that those kinds of points with respect seem to be going to the merits, which presumably we'll get onto in short order. Yeah, so are you saying then that you are not happy with the undertaking that they have given?
Well, we've said that in writing, and we will say it again. But with respect, Your Honor, I am dealing with what this court has said are the considerations that the court must consider when it comes to consider an application for interim measures. I'm taking it directly from paragraphs 30 and 31 of the judgment. So I'm addressing the balancing of the interests, and I'm addressing whether it is just or unjust to grant a measure.
I understand. With respect, I understand you perfectly. All I'm saying is that when you talk about the balance of payments or the debt, you refer to a newspaper article about the debt. I am suggesting to you that those matters are probably better dealt with at the merit stage, because if Mr. Benjamin's client will make good the CET, if the case goes against them, then all of those issues that you just mentioned would go away, would they not? The government would still get the same revenue that they would have gotten.
Well, that is to assume that the undertaking that has been proffered is of any value, and we've addressed that in our submission.
Yes, so I'm suggesting, shouldn't we then pay a little bit more astute attention to that aspect of it then, rather than the macroeconomic situation?
Well, we will come to that. We will come to that, Your Honor. But respectfully, I must address each of the considerations which this court says are relevant to be considered by a court when considering an application for interim relief. And as you've made that point, it leads me to the reality that on the evidence before the court, there are only 2 more shipments coming into Trinidad, which is February and March. And therefore, if it is the court were to grant the interim remedy sought, they wouldn't be in effect getting more relief than they're asking for in the application. And this goes to a point that Your Honor raised with them. Have they actually asked for the decision to be quashed? The answer is no. And I can take you to that relevant part. But even if they were to ask for it, in effect, they would be getting all the relief, which they haven't even yet asked for, but they might wish to ask for, at the end, if they were successful. And it goes to the point that Your Honor raised, well, my learned friend made a lot about consultation, but at the end of the day, where does it all take him to? Does it take him to question the decision of COTED? It doesn't.
Yes, I'm with you on that point. It's just that he also raised, unfortunately for your argument, other points as well, which he says support the more expansive relief that he's seeking.
Well, he may have said what they would, but in our respectful submission, I don't think that they support it. But I am assisting the court on the balancing of the interest referred to in paragraph 30. I
apologize, Mrs. Speak, if I seem to be suggesting that you take a different approach to developing your arguments. Please do it in the way that you wish. For my part, though, I think we should try and stay a little bit away from the macroeconomic side of things, because I'm not myself too expert in that.
Well, in our respectful submission, that is fundamental to understand the state's case, because the state is saying we have a substantial budget deficit, we have a shortage of foreign exchange, we need to promote the local industry which is earning foreign exchange, because we have to run the country and try to manage a budget.
And I'm saying all of those arguments will prevail at trial. And if you prevail at trial, any shortfall in the revenue to the government of Trinidad and Tobago will be made good by the applicants, unless, of course, you doubt their undertaking. And if you do, then obviously we need to spend some time interrogating that. In other words, and I had a similar, I must say, I had a similar concern when Mr. Benjamin was presenting his case as well. It seemed as if we were really trying the merits to a large extent. But as I said, I don't wish to detain you. If you wish to develop it in the way that you're doing, please.
Much obliged. And on the balancing exercise, because the court is weighing up the interests, we say when you look at the applicants, and what their interests are. On the evidence, they are seeking to import cheap Turkish cement at very low rates of tax, which would put the local manufacturing company out of business. And we say it is clear, therefore, where the balance of justice lies. And that is what the court has to consider in determining whether interim measures should be granted. In addition, we say that in carrying out the balancing exercise referred to in paragraph 30 of the judgment, we would respectfully urge the court to look carefully at the evidence filed by the applicants in support of the application for what we say can only be described as a far-reaching and unprecedented order to prevent a member state of CARICOM from imposing a tax to raise revenue and to protect the interests of the domestic manufacturer, which this court has held is ultimately a matter of domestic economic policy. In this regard, our respectful submission is that the evidence in support of the application is unsatisfactory and in some cases just misleading. So, for example, the applicants approaching the court for interim measures say that they do not even know which of the local companies imported cement into Trinidad and Tobago, and you will find that in paragraph 8 of the principal Ramit affidavit at page 72. Next, your honors may have observed that they've lumped the two local companies together under the acronym RHTT, so it is unclear, and perhaps that was the intention, which company they are referring to in the application and the affidavits. Next, they have not disclosed that the second applicant, which we say they must know, Rock Distributors Limited, has never imported cement into Trinidad and Tobago, neither has the first. They have not disclosed that the only one of the applicants, which has imported cement into Trinidad and Tobago, is the third applicant, which is an established construction company, and that there are other companies in the Ramit Group which share assets and resources, so that the likelihood that the applicants are going to disappear, which is the language used in the Barbados injunction case, if the tax is increased by 15% over what it was in 2020, is, we say, wholly lacking in credibility and frankly inconceivable. We say the hyperbolic statements of loss of the multi-million-dollar investment and the companies being ruined and closing down is simply not supported by the applicant's evidence. The applicants also did not disclose that at the time when the order would have been placed, or when the ship leaves Turkey for the February shipment and perhaps the March shipment, they knew that the CET approved by COTED was 50%. So they took a business decision to import under that regime. And we ask the court to note also that the first applicant says that it entered into a contract to purchase 1.75 million tons of Turkish cement when the CET in Trinidad and Tobago was 35%, and knew that since 2019, this court had recommended that COTED undertake a review of the CET on other hydraulic cements. And of course, the CET has been paid on the January shipment. So nothing on the applicant's evidence we submit discloses that an order for interim measures that is sought is needed. And this is what is required to be established to the satisfaction of the court under Rule 12.12. We say further that as this is not a dispute between two private parties, but between the state and the applicants, in determining whether it is just or unjust, which is the language used at paragraph 32 of the judgment, to grant the measures sought, the court has to have regard to the public interest, not simply the alleged rights of the applicants to be permitted to import at a low rate of tax of 0 to 5%. We say, having regard to the clear and consistent statements of the court since 2009 as to the purpose of the CET, we say respectfully this is simply not a right which the applicants have under community law or at all. Contrary to the applicants' assertions of a business or businesses in decline or facing closure, Ramit, as we call the company, Modular Ramit, the third applicant, not the first nor second applicants, which have never imported cement into Trinidad and Tobago, imported more cement in 2020 when the CET was 35% than it did in any of the preceding 4 years. And of course, the court notes this was during the height of the pandemic. And you will find this at paragraph 15 of Permanent Secretary Leachy's affidavit at page 1096. This is also, we ask the court to note, at a time when this was a 600% increase in the duty payable from 5% in 2019 to 35% in 2020, and increasing the volumes of imports. Imports of cement in Trinidad and Tobago dollars increased by 40,400% over the 5-year period. All of this is undisputed evidence. In fact, Ramit imported nearly 35% more than in 2019, and the average retail price of imported cement in 2020 decreased by $1.33 per bag over 2019. And you will see this at page 280, which is the proposal to COTED. And we say that this is likely due to the precipitous depreciation of the Turkish lira, which was 87% over the period 2016 to 2019, and a further 30% between January and October 2020. And you will find this at page 834, which is the affidavit of Ms. Allen Ovid. Obviously, on the evidence before the court, this is a profitable business which was growing, notwithstanding a CET of 35%. And therefore, the only reasonable conclusion that one can come to on the applicant's evidence is that it will not fall or disappear if the tax is increased by 15%, which is the reality.
Was the increase of the CET to 35% time bound at all?
Yes, it was for 1 year. January to December 2020.
So could it have been that they anticipated that, well, at the end of that period, the CET would have reverted to the original rate, and that is why they kept going?
Well, on the evidence, the timing is that even before the consultation started in September, the first applicant had already entered into a contract with some entity in Turkey to purchase 1.75 million tons. And therefore, the question is, what difference would it have made even if they had been consulted? They had already made a business decision when the tax was 35%. So they didn't do it on the premise it would be 5%. They did it on the premise that it was 35%. And if they had regard to what the court had been saying since 2009, that 15% is at the low end of the scale, then I don't think it would have been reasonable for them to expect it to revert to 5%. But I mean, this is what we expect business people to do when they're planning and making projections. And realistically, Jamaica has a CET of 50%, Barbados has a CET of 35%. So why they are operating in those countries as well? Why would they expect the CET to go back to 5%? On the evidence, that would not have been a reasonable expectation in our respectful submission. Now, when you look again at the undisputed evidence, in 2020, the domestic manufactured TCL's market share dropped by 18%. 54%.
But you would agree, though, Mrs. Speak, that there might be a limit to which the business can absorb increases in taxation. I mean, you mentioned 50%, but
as a risk of
what if the government went to 85%? I mean, is there any kind of limit at all, or not?
Well, respectfully, there is no limit on what a sovereign state can decide to impose in relation to taxes. Of course, yes, one business may be able to bear an 85% increase while another may not be able to bear it. But the question is, do you have any legitimate expectation to trade on the basis of the same tax that was enforced when you commenced your business? That's the bottom line.
Yes,
there is no expectation.
I agree with you that is a very critical issue as well. And I don't think anybody on this panel would dispute the sovereign right of the government to tax at whatever rate it wishes. I think the issue is whether it is reasonable in the circumstances, in the interest of a stable business environment, that businesses are alerted to or given notice of the intention of the government to exercise its sovereign right. And I don't know what you think about that, but it seems to me that it does make a kind of sense that businesses need to know, what the government is planning to do, thinking of doing, or will do, so that they can make their business decisions. I would have thought that reasonable, wouldn't you?
Well, I would think in an ideal world that would be great. In other words, if I knew they were going to take up the tax on cars, I might go and purchase a car. If I knew they were going to take up the taxes on alcohol, I might go and purchase a case of alcohol. But that is not how government works.
You're talking about yourself as a consumer. I'm talking about
as a purchaser as well. Or if I carry on business, I operate a practice, and the taxation rate is 45%. What am I going to say if the government wants to take it up to 65% because of a $13 billion deficit? The government has to give me notice. With respect, Your Honor, that is not a realistic proposition. In an ideal world, everyone would love to know what a government plans to do and what decisions it's going to make that might adversely affect it. But when you have...
The difference, Counsel, is that I gather one is not just looking prospectively and making decisions about, further future action. What the applicants are saying, if I understand them correctly, is that the decision that is being made now is having an effect on actions that they have taken already, business actions that they have taken already, contracts that they have entered into already. So I'm just wondering, from the government's point of view, whether there isn't some merit in giving some kind of notice, so that businesses can plan their activities ahead of time.
I mean, as I say, in an ideal world, in an Orwellian world, that would be perfect. But the bottom line is whether there is any right to have a regulatory regime or taxation regime remain as it was when I commenced my business. And I say that particularly in the context where we say since 2009, this court has been saying you have to have a protective regime if you have a domestic or regional manufacturer, and 15% is on the low end of the scale. And I say that when they entered into their contract in August, which by the way we haven't seen, they knew that the regime was 35% for a year, and it was the practice of states, including Trinidad and Tobago, to go back to COTED to have a further suspension. I mean, these companies know they were involved in the Barbados litigation, where there were repeated approaches to COTED for suspensions and a tax being imposed outside of the 0 to 5%. So this is no magic. It didn't come to them as a bolt out of the blue. They have been operating in the Caribbean since 2015, knowing that in Barbados it was 60%, then it went down to 5%, and then went back up to 60% by operation of an order of this court. So again, the court doesn't wear blinkers. We're not dealing with a hypothetical situation. We're dealing with these commercial entities which know the power of COTED, which know what the CT says, and they know that the regulatory regime may change at any time. And it is not the practice of a government, and I say for very good reason, to give notice to business people. It happens all the time. When a budget is announced in Parliament, the government doesn't in advance give people notice, look, this is going to impact on your business, or this is going to impact on your consumer, because it is well known that if you make the announcements in advance, then the very object that you're trying to achieve may be negative. So that is why I say in the circumstances of this case, particularly as we say, the undisputed evidence of when their contract was entered into, which is August 2020, they really can't make out any serious case for contending that it came to them as a surprise, even though there was consultation taking place in September, which they chose not to participate in, that there was a likelihood that the CT would increase, because they knew that their market share was increasing. They knew what the impact on the local manufacturer would have been by their presence on the market, and they knew what this court had been repeatedly saying in relation to protecting the local and regional manufacturer.
I follow you. I just want to be clear, because you touched on something earlier, and I wasn't sure whether you're going to come back to it. The issue of the meaningful consultation, and you sort of dealt with it in a very cursory way by saying that you did not think that there was an obligation on the government to disclose every single piece of communication, which it might have gotten from, let us say, TCL in this case. Are you going to come back to that? Because I just want to be clear that you are saying that there was no obligation on the state of Trinidad and Tobago to disclose to the applicants the fact that, it seems, you can correct me if I'm wrong, the state of Trinidad and Tobago had received communication from TCL indicating its suggestion of the increase in the CET, what the nature of the increase was, and the rationale for it. Are you saying that, in your view, there was no obligation on the part of Trinidad and Tobago to disclose that proposal?
I'm saying, sorry.
Or are you going to come back to it? I didn't want to.
Well, perhaps I can deal with it now. I'm saying there is no obligation at every stage of a consultation process to disclose the persons being consulted, what documents have come into the possession of the person who is doing the consultation. That is not the law as we understand it, and that is not how we've construed this court's decision in the consultation case.
Not so much the personalities or the the letterhead, but the substance of the suggestion which had come and the rationale for it, perhaps. You say there was no obligation to disclose any of that.
Yes, that's precisely what I'm saying. Okay. Can I refer the court to paragraph 58 of its judgment in the consultation matter, which is page 541. And this is what the court said. The importance and value of the consultation process will vary from one case to another. In another case, the object of consultation may have been to obtain views that were unknown, so that those views might be of genuine assistance to the decision maker, including, very importantly, possibly influencing what decision to make or whether to make it. In this case, the proposed revised procedures, if they had been enforced and properly followed, required COTED to be provided with information obtained by the competent authority as a result of consultation as to the potential impact of the proposed suspension and specific increased tariff for which the state of Barbados had applied. The circumstances here indicate that neither the state of Barbados nor COTED could have had the slightest ignorance that the proposed suspension and the specific tariff increase applied for would have had a significant impact on Rockard. These parties were the material time in litigation precisely on issues surrounding the tariff on other hydraulic cement. The nature, even if not the precise details of the impact on Rockard, was obvious to all. And at page 59, the court continued. Nevertheless, this court does not now consider that these failures should lead to the drastic measure of annulment of the COTED decision in light of A, the fact that here the object and benefit of consultation were limited, namely to obtain information as to the impact of the suspension, and I emphasize that that is the object and benefit of consultation which this court has decided. It is limited, namely to obtain information as to the impact of the suspension, and B, the context of the particular grounds on which the application for suspension of the CT was made, recognized and afforded a wide discretion to the policymakers. The court does consider, etc. So that is the purpose of the consultation. It is not an iterative process where every document that comes to the decision maker, I must send it to each of the parties being consulted. That is not the object, particularly where there may be confidential information disclosed by any one of the parties. None of the documents that Rockard or any of the local companies provided us was provided to TCL. That's not how we run a consultation. So even a common law, and that is not what this court has said is the object of consultation, that is not the obligation on the decision maker.
Yes,
and therefore we say, sorry.
No, sorry, I was just saying I'm clear on your position. Thanks. Yeah.
Much obliged. So I was on the point that they also, so we talked about the contract and what they, that they knew full well when the orders were placed, and in that regard I will refer you to A012 to the Allen Ovid affidavit at page 1077, where the instructing attorney for the applicants make it clear that when it is, sorry.
Ms. Speaker, how much more time do you need?
No more than 10 minutes.
Okay. Please continue.
Much obliged. So I got to the point about the public interest. Just give me a moment. Let me just get my bearings.
Dropping off the share TCL.
Yes, so I'm looking at, having looked at the applicant's position, I'm now looking at TCL's position and what those statistics show. And there was a 47% reduction in revenue over the period 2016 to September 2019. And in fact, TCL's production dropped by more than half over the period 2015 to 2020. And for this, I'd ask refer the court to paragraph 20 of P.S. Allen Ovid's affidavit, and that's at page 828. And we say, is this what this court expects COTED and the state of Trinidad and Tobago to promote underutilized factors of production? We say that is not what Article 6B of the revised Treaty of Tragaramos contemplates. So on the evidence before the court, including the state's evidence and TCL's evidence, which we say respectfully is not only undisputed, but clear and cogent, it is quite clear that in balancing the interests of all persons directly affected by the proposed order for interim measures, TCL and the state will be far more adversely affected than the applicants if the order sought is granted. And in fact, the applicants have provided no evidence to establish why an order for interim measures is necessary pending the hearing and determination of the claim. In the Rockard and Barbados matter, which is tab 2 of the applicant's bundle, it was not disputed, and I think this is a point that Your Honor Anderson was alluding to at the commencement of Learned Friend submissions. In that case, there was no prior notice of consultation, and the court held that the defendants had failed to ensure that the claimant was consulted before the CT was suspended, and the court in that case did not quash the suspension, but granted a declaration. So we say, on the authority of the decisions of this court, and in particular that one, even if the applicants were to succeed at the end of the case, whereas the evidence shows there was consultation and engagement with the second and third applicants at the domestic level, unlike the Barbados case, the court is not likely to quash the COTED decision. As the court reasoned at paragraph 73, the inescapable fact is that Rockard cement is in competition with cement locally produced by the intervener. It is ultimately a matter of domestic economic policy, whether consistent with its development strategy. The state of Barbados, we say the state of Trinidad and Tobago, wishes to promote the importation of Rockard cement or encourage the intervener's local cement production. And if one or the other, what measures it should take in this regard? Successive administrations must be permitted the policy space to take such measures as they may consider appropriate. We respectfully commend those words to this court, because if you apply the language in that statement, it certainly militates against the grant of the order sought. The court asked me to deal with the undertaking as to damages, which we dealt with in our written submission. At paragraph 32. And we say that is nothing more than a bare assertion unsupported by evidence of the applicant's financial ability to honor any such undertaking. And in any event, even if they had met that evidential threshold, an undertaking cannot be adequate, given that the non-imposition of the 50% rate of duty and a return to 5% rate, this is at page 1698, will leave the domestic manufacturer exposed to significant underselling in the domestic market without the protection contemplated by the framers of the treaty as interpreted by this court. So quite simply, you don't just come to court and say, I am willing and able. Your ability must be demonstrated by evidence. And at paragraph 33 of our submissions on page 1699, we point out that on the applicant's own evidence, they were able to absorb a duty of 35% in 2020 while growing their market share. They have not provided this court with their projected prices if a rate of 5% is to be applied. And the likely outcome is significant underselling of the domestic manufacturer with reduced demand for locally produced cement, a consequential reduction in TCL's production capacity, and its ability to earn much needed foreign exchange for the economy of Trinidad and Tobago, loss of employment in circumstances where there's already been retrenchment from TCL. And we have in the presentation that was made by TCL that is before the court, evidence of what would happen if in fact they move from a manufacturer or producer of cement to being an importer, where instead of being a net earner foreign exchange, they will be utilizing foreign exchange.
Mrs. Speak, could I ask you, just switching back for a moment to the undertaking, you say that the bare assertion is not enough. Could I ask you what more do you want to see? What more would you?
Financial statements for one thing.
Financial statement.
Audited financial statements to show what the capacity of the company is to meet the undertaking as to damages. And you know, I don't want to trespass on Mr. Jeremy's ground, but they make a very valid point that if in fact they did have the capacity to meet the undertaking, then they can pay the tax. And if it is
I'm not a businessman, so I'm not sure I want to comment on that.
But I think it's an interesting way of looking at so on. So you know,
but you're dissatisfied with audited financial statements. Okay.
Audited financial statements, or I think what was suggested was some kind of report being done showing what the the financial capability is. But in our respectful submission, we don't get there because they haven't been able to establish the prima facie case of success. They haven't been able to establish the serious or irreparable harm to their rights.
Just in case the court decides against you. So you want an audited financial statement, or you mentioned a report. From whom should that report emanate?
Well, I would think some independent, just as audited financial statements would give you an idea of a third party, some kind of third party assessment of what their financial capability is.
Have you? I got you. Yeah. Okay. Thank you.
Which I think was what had happened in the case, in the TCL case, where the injunction was in fact granted. They put a substantial amount of material before the court to establish that they would have been able to be good for the undertaking.
Yeah.
Mr. Speaker,
yes.
I suppose that what is needed depends from case to case. What is the information that we have? For example, you're saying there is evidence that despite the 35% in 2020, they succeeded in even importing more cement. They didn't raise the prices. So maybe against that background, a little more needed than in another kind of case. Is that?
Yes.
Okay.
Well, on the one hand, it is showing that there is no serious or irreparable harm. It is showing that they obviously are carrying on a business that is profitable. But on the other hand, if it is you're going to give an undertaking, you need to have more than that, particularly since this is a group of companies and one isn't quite sure which company we're dealing with at any one point in time. So, and I think the Malayan Friends for TCL have reached an interesting case where it points to the very evidence that we have in this case, where you have a group of companies. It's very difficult, if not impossible, to establish that there is going to be this destruction or disappearance or ruination when you have other companies in the group that can make good the tax, which is what we're talking about, which is effectively on 2 shipments, which is about 20,000 and another 70, about 37,000 tons of cement, which are going to be brought in February and March. And there is nothing to suggest that they don't have the wherewithal, as they were able in 2020, and as they were able in January 2021 to pay the tax. And therefore, what is this all about?
So the tax is about $19,000, is it?
No, sorry. The number of tons that they have to import for the rest of this year is 37,100. They brought in 20,000 in January, and they paid the tax. So they have not suggested, and this is the burden on them, that if they have to pay the tax on 37,000, which is, not even twice what they brought in January, that they're going to crumble. And that really is the evidence that they must put before you under the second limb in paragraph 31. What is the serious or irreparable harm to their rights that they will suffer if these 2 remaining shipments, which were ordered at a time when they knew the regime was 50%, they're going to suffer. So just to conclude, we say, on the totality of the evidence before the court, we say it would be wrong and certainly unjust to use the language in paragraph 32, sorry, of the injunction case to grant the relief sought, which we say that they are unlikely to get at the end of the day. And we respectfully invite the court to dismiss the application for interim measures with costs. Unless there's anything else we can assist you with, we would urge you to look at the written submissions. And I made the point that there was no, even though my learned friend said yes, they did seek it, there is no order trying to set aside the decision of COTED. And you will find this at paragraph 109 of the draft originating application at page 64. So they're not even going to, they haven't on the originating application now before the court, which is what the court must look at to determine whether there are factual and legal grounds to establish a prima facie case of success. There is no order being sought to set aside the decision of COTED. And therefore they can't get more than what they're asking for the end of the day. And of course, we make the point that the grant and the order sought will give them more than what they're asking the court to do at the end of the day. Unless there's anything else we can assist you with, those will be our respectful submissions.
Thank you very much. I think it's time to take a short break. Unless irreparable harm will be caused. I think we could take 10 minutes, which would take us a little more than that, 25 past 4. 25 past 4, we could continue.
Your Honor.
Yes.
Might I just ask, the question might be premature, but might I just ask how late we propose to go?
Well,
when we return, there's CARICOM to go. I have to go. I'll be very brief.
Okay. Well, let me ask Dr. Babsheva, how long do you think you need? We don't have to repeat all the arguments, of course. There are 3 on one side, defendant sides. So how long do you think you would need?
Yes, I think I'll need about 15 minutes, Your Honor.
15 minutes. So that would take you home, let's say, by 5, Mr. Jeremy. Is that enough, or would you want to go first?
I would love to go first, but I'm not sure as an intervener.
Well, that is really intervening, actually.
I'm not sure we have granted his application to intervene, Chairman. So.
Well, I'm not sure about that either, but he doesn't have to intervene, as I said, according to the rules. He could simply come. Yeah, well, from a practical point of view, Dr. Babsheva, would you mind being the last in this? Well, you won't be the last because Mr. Benjamin will go last, but could we reverse this order a little bit?
Yes, Your Honors.
Okay. Well, so we will deal after the break, 25 past, we start again. We will shortly deal with your intervention application and then go straight, if that is all right, then we can go to your submissions.
Thank you. Yeah.
Okay, so we'll have the break till 25 past.
Yes, Judge.
Okay.
I'm seeing. Yes.
The judges are here and
Judges
counsel are here.
Yes,
So-
Dr. Bab Schaefer, are you there? I'm not seeing her on my screen. But I'm seeing Mr. Jeremy, senior counsel. I'm seeing Mr. Benjamin.
Yes, but we would like Dr. Bab Schaefer to be here too before we start.
Okay, Judge. Let me see.
I thought I saw that she was in the so-called waiting room.
But she's not showing up in the waiting room on my side, so I'm not.
Okay.
And I think prior she was having some challenges, so she's now in. Dr. Bab Schaefer, you hearing us?
Yes, I am. Thank you.
Yes, good.
Oh.
Thank you, Judge. You can proceed.
Okay. Well, Mr. Jeremy, I think you filed an application to intervene in these proceedings. We already discussed the scope of that intervention, practically mainly to make submissions in the context of the interim measures. But as it is an intervention, it might also be for the rest of the procedure, depending on how far that will go. And in that case, the rule tells us, of course, that there should be it should be served and so forth. But we can make things very simple, where and I can ask Mr. Benjamin, Ms. Peak, and Dr. Bab Schaefer if they have any objection to the intervention.
None, Your Honor. We have no objection.
Okay, Ms. Peak.
The state of Trinidad and Tobago has no objection.
Thank you, Dr. Bab Schaefer.
Sorry. Likewise, Your Honors, the Caribbean community does not have any objections.
Okay. Well, then, unless I'm stopped by one of my colleagues, I think I can say that that application is all right. And that means that you can speak, Mr. Jeremy.
Thank you, Your Honor. Your Honor, I adopt the argument set out by my colleague and friend, Mrs. Peak. But I would like to begin. I'm going to be short because I'm not going to repeat anything that she has said in her submissions, and she has spoken to TCL quite a bit, and anything that has been canvassed before. But if I can take as my jumping off point, as it were, the place where my learned friend, Mr. Benjamin, stopped. Mr. Benjamin ended his submissions by summarizing that on the evidence, and I think I took a note. I was careful, but I make mistakes often. Mr. Benjamin said that the evidence and allegations which are set out in his papers evince a pattern of conduct which allows him to complain that there are prima facie grounds which support his application for interim relief. Now, that's what he said, but in the course of his impressive contribution, he elaborated on those grounds. He spoke of the lack of adequate consultation. He made complaint of the proper interpretation of Article 83. he made complaints as well about our evidence in terms of the shortfall. We have an affidavit which is before you, in which we say that we have had in the past couple of years a tremendous shortfall in revenue amounting to billions of dollars. And as I understand Mr. Benjamin's complaint, it was that to the effect that there had been a failure to establish a causal link between our losses and his activity. And finally, he made complaint of certain, what I would describe to be matters which are properly cognizable under the WTO dispute resolution procedures. That's how I categorize it. Of course, Mr. Benjamin did not categorize it in that way. Now, the point is, Your Honors, that just on the application which is before us this afternoon, and I think Your Honor, Justice Anderson reminded us that what is before us is not the substantive claim, it is the application for interim relief. Just on that, my learned friend, Ms. Peake, reminded us of the principles which this court has set out. And if I can just see, I'm not going to repeat those principles, but the point is that in the affidavit which we filed, the affidavit of Guillermo Rojo, at paragraph 15, Mr. Rojo points to disastrous consequences if, in fact, relief that my learned friend seeks, my learned friend Mr. Benjamin seeks, if that relief is granted. And at paragraph 15, there is set out correct earnings, because that the business model of my client is going to have to change. That leads on to his next point, which is that there will be job losses. If you read the affidavit, you see, I'm going straight to paragraph 15, but if you read the affidavit, he says that it's easy to import cement. It's more difficult, it's something more difficult to establish a plant and to pay taxes and to have a workforce and to do these sorts of things that a local producer does. And those consequences, Your Honors, are what I would like to stress from the point of view of the intervener would follow in the event that the measures sought are in fact granted. Now I adopt the law that, as I say, I adopt the law that to speak, and this court has repeatedly pronounced on. I think I heard Mr. Benjamin say that his contract to import, with which he has various complaints. I'm not touching on those complaints, those complaints speak to the substantive issue. But his contract was for 1.75 million tons. Is that, I think I heard him correctly on that. Well, my Lord, Your Honors, I'm sorry. The entire local domestic market is 350,000 tons, and that's going to eradicate the market in cement, has the potential to eradicate the market in cement. And I think that ends the survival of the domestic industry forever. So that I think is a consequence which this court would bear in mind in terms of making the necessary, but engaging in the necessary balancing exercise as to precisely what to do in respect of the applicant's application for interim relief. And Your Honors, that is all that I propose to say. I said I'd be very, very brief. That is all that I propose to say on this application. This is not the substantive application. I take that point. I'm not arguing the case. I'm just arguing against. My affidavit is in opposition to the application for interim relief, and that is what I have sought to do this afternoon.
If I may, Mr. Jeremy, I thank you very much for taking that approach, which I think is very helpful. But there's something I'm not quite clear on. I'm not sure what clearly is the position of your client in relation to the interim measures as far as the effect on your business or their business is concerned, because now I understand the financial pain which will be visited on the government of Trinidad and Tobago if the interim measures are granted, even though, of course, as I indicated, depending on how you value the undertaking, that could be remedied. And I also understand the financial pain which could be visited on the applicants if you take the arguments of Mr. Benjamin to heart. But I'm not quite sure exactly how your clients are situated in relation to this matter, because if the duty is paid, then the cement comes in. So that all of the points you make about the impact on your business and employment and so on, that those impacts will be there if the duty is paid. Would it not? Am I missing something?
I respectfully, Your Honor, if the duty is paid at the rate that
right.
It is what we say, the
50%.
The authorities say it should be paid.
Yeah.
Our business model is able to survive that. It cannot survive a rolling back of the duty, so that the application which is before you, Mr. Benjamin is clear that the application which is before you is to suspend the position of that 50%. Now, we participated. The affidavit evidence says that we participated in the consultation process. We were consulted. We did what we were supposed to do. We did not take points. We did not say, well, I'm not sure if we are properly invited to this consultation, or if show us the agenda for consultation or disclose the material which others have put before you. We were in dire straits. So when we had the opportunity to consult, we seized that opportunity and we consulted. We put our case to the authorities. And the authorities would have engaged in what I imagine would have engaged in a proper exercise. Mr. Benjamin says no, and I mean I take the point that a lot of the complaints which I hear sound in public law judicial review consultation. I'm not sure if they are cognizable in this court, but I do not wish to get into the substantive case. The point is that we participated. We now have a situation where a tariff has been imposed which will protect us. And what Mr. Benjamin at the 11th hour, at 5 to 12, seeks to do is to say, no, I might not have participated, but I have a problem now. And you're not entitled to the fruits of what the authorities have provided to you.
I will take on trust your point about the business model. I need to be further educated on the implications of that for the sustainability of the business. I just had that little issue which I thank you for trying to help me clear up. Thank you very much. Yeah.
Well, it is. I take it on trust too. It's a statement on oath, and it is not contradicted.
Sure.
Mr. Jeremy, and now I'm reasoning just from a very practical point of view, and I'm not suggesting at all that we would be willing or unwilling to honor the application. But there are so many ways that you could deal with these kind of interim measures. For example, and this is my question, if we would say, okay, well, for the time being, it will go back to 5%, but the 45%, which is the difference, will go in an escrow. That is then the guarantee that you give. So in that case, they still have to pay the 50%, be it 45 in an escrow and 5% right straight to the government. Would that hurt your business?
Lord, I would, Your Honor, I would have to take instructions on that. I'm not an expert myself. I find myself in a similar position to your brother, Justice Anderson.
I just think in a very practical way, if they still have to put up the 50%, then that will have the same effect, except that 45% is put in a safe deposit, so to speak, so that if they win, then they would get that money, but if the government wins, so to speak, the state, then they would get that. But I'm just trying to find out what would be practical. An interim measure could also be.
I must confess that even without the expert knowledge that Justice Anderson says he does not have, that is something that occurred to me. So I don't have that expert knowledge.
Okay.
I did think, what if we because in my reading I have seen instances in which that has been done.
Mm-hmm.
So
yeah.
Mr. Jeremy, I didn't get the impression, though, reading all these papers, that putting 45% in an escrow account would have accomplished what the government of Trinidad and Tobago was trying to do. Yes. I really did not get that impression. As I understand the case, the market would still be flooded with imported, low-priced cement. And that is what I thought was a mischief in inverted commas only that was intended to be eradicated. So if I'm wrong about that, but I thought that was the whole idea of what we've sat listening to from Mrs. Speak in particular for the last hour or so.
But I would defer to Mrs. Speak on that. I should have thought that if you ask the applicant to pay 50%, that, I mean, I can't speak for the government, but if you ask the applicant to pay 50% as we progress in this case, that the mischief is alleviated. I say that with a great deal of trepidation, because I am not, as Your Honor, Justice Anderson has said, an expert on that. I came to object to my learned friend's application, which is not that application. His application is for a rollback of the 50%. So I don't wish to be held to anything on that. The government might have a position on that, which I don't wish to tie their hands on that.
Sure. Well, maybe before we go to Dr. Bob Shiva, Ms. Speak, and I'm just very practical here, and this does not mean that my thoughts are going in this or that direction, but well, simple thinking would say, well, if Ramit has to pay the 50%, but 5% straight to the government and 45% in an escrow, okay, then the government doesn't get that money yet. But if you win, you will get it eventually. You will be sure that you get it. What would be your objection to a solution in that direction? And I'm not saying that we're thinking of that, but I'm just trying to figure out where the possibilities are.
My response to that would be, I don't think the court with respect should be giving consideration to granting any such order for a number of reasons. One, for you to exercise your discretion to grant any relief on the application, you have to meet, or the court has to be satisfied that the criteria set out in the Barbados matter have been satisfied. That's the four-prong test. That's one.
That is clear. That is clear.
Two, I say that with respect would make no sense, because the applicants have come to the court and they've said they cannot pay 50%. And they didn't say they cared where it had to be paid to. They say they cannot sustain 50% because they would be destroyed. So that is not what the applicants have asked for in any event. And third, more significantly, it does not meet the undisputed evidence of the Permanent Secretary, Ministry of Finance, that says one of the reasons why we've implemented this 50% tax is because we have a significant revenue shortfall. This is paragraph 11 of our affidavit at 1095, a decline of approximately 27% between September 2019 and September 2020. A 40% reduction in exports in the period January to September 2020. And as I've indicated to you, we have a budget deficit of in 2019-2020 of $16.7 billion. We need the money. And therefore, to say to pay it into an account is not going to meet the justification for imposing the measure in the first place. We are in a critical financial situation where every dollar counts. The Permanent Secretary has said we estimate $10 million in revenue. The court is saying put that money into an account. I know it's a possibility.
You are very clear, and I'm I'm sure that Mr. Benjamin wouldn't like that proposition either, but I'm just trying to find out in a practical way, if it ever would come to that point, what kind of interim measure would be a real or a practical one. He will get the opportunity to speak about it and other things when we have heard from Dr. Bob Schaefer. But anyway, thank you for your...
Much obliged.
Dr. Bob Schaefer.
May it please your honors. May it please your honors, I would like to deal with two aspects of the test for interim measures. So one, whether the applicant has established prima facie the right in support of which the interim measure is sought, and two, whether it would be unjust to grant the measures. In relation to the prima facie case, I'd like to start by looking at part 12.12a of the CCJ Original Rules 2019, which provides that the application for interim measures shall establish prima facie the right, and this right must be in support of which the interim measures are sought. So there's a link between the rights established prima facie and the interim measure sought. So the question then becomes, what is the interim measure sought? The interim measure sought is an order prohibiting the first respondent from imposing a rate of duty of 50% on other hydraulic cement or any other rate other than the CET rate of 0 to 5% fixed under Article 82 of the revised treaty until the hearing and determination of the originating application. So in essence, the effect of the interim measure is to quash the decision of COTED until the hearing and determination of the originating application. So the issue that falls for determination is whether the applicants have established prima facie that there has been a breach of their rights under community law, which entitles them to have the CET rate of 0 to 5% applied to other hydraulic cement. I'd like to go through very briefly the issues raised by my learned friend, starting first with consultations. My learned friend has said in relation to consultations that the consultations were not meaningful. He's not saying there was no right, there was no right at all, that they were not consulted, but the consultations were not meaningful. Well, the originating application indicates that the first applicant is not an importer of extra-regional cement in Trinidad and Tobago. Accordingly, that applicant has no right in community law to be consulted on the decision to authorize authorize the suspension of the CET in relation to cement. It is stated in the OA that the second applicant is an importer, but the first respondent has said that it is not an importer, and the second applicant has not established that he is an importer. So if it is true, indeed, that the second applicant is not an importer, then it has no right to be consulted. The third applicant is an importer. The third applicant is complaining about the quality of the consultations, and your honors will see the correspondence where instead of focusing on the potential, the third applicant focused on whether Trinidad and Tobago had complied with its WTO obligations. And there's more than one letter in relation to that. But even if everything that my learned friend for the applicant said was correct, even if everything was correct, that still will not entitle the applicants to an order that the COTED decision was ultra vires and that the CET should be applied. There is no community law not even Rock Hard in the state of Barbados in the Caribbean community and Arawak Cement Company Limited. There is no community law that states that a lack of consultation with extra-regional importers without more renders a decision of the COTED authorizing a member state to suspend the CET ultra vires a fortiori, as in the present case, where the question is about the quality of the consultation or the adequacy of the consultation. There is no community law concerning consultation that without more will give the applicant a right to have the decision of the COTED authorizing the suspension declared ultra vires and quashed. So the applicant has not shown that the right will support the measure sought, and the measure sought, regardless of how we call it, the measure sought is to quash the COTED decision until the hearing of the case. That is the reality. In effect, that is what we're dealing with, Your Honors. I would now like to turn to Article 83.
And may I ask you something? You said without more. So the law is not that some failure in the consultation without more will nullify, let's say, the COTED decision. So what more would be needed then, or what?
We would say there is no more. But all I can say though is that based on the Rock Hard case, where the facts are similar to this.
So, but does it mean that I'm just asking your views? Does that mean that okay, if there is a failure, I'm not saying that that is here the case, but if there is a failure in the consultations, it was not meaningful or whatever, and there is something else wrong, that culmination may make such a decision null and void?
Right, in relation to another ground. So if they could have proven that there is a right that was breached, a right that was breached prima facie, then, and that right, the consequence of the breach of that right is to decision to be declared ultra vires, then in that case. But not in this particular case, because we have the same facts as Barbados, as in the Barbados case, and the lack of consultation did not lead to the decision being rendered ultra vires. And in fact, Your Honors, in this particular case, the first respondent went much further than the first defendant in the Rock Hard case. The first defendant wrote letter after letter after letter. And the preoccupation of the applicants, Your Honors, was, have you complied with your WTO obligations? You haven't complied with your WTO obligations. They were not interested in focusing on the impact on the suspension. Okay, Your Honor. So moving now to Article 83. So the applicants, they submit that on the basis of a proper interpretation of Article 83, the information did not support the authorization to suspend the CET that Trinidad and Tobago got. Now, the material provided by the first respondent in this case is more than that provided by the first defendant in the Rock Hard case. And Your Honor said, given the material before COTED and the decision made at the meeting, the court could not reasonably come to the conclusion requested by Rock Hard that the decision was ultra vires. If, and that is at paragraph 74, and if Your Honors could not, on the basis of the information provided by the first defendant, Barbados, in the Rock Hard case, come to the conclusion that that decision was ultra vires, the second defendant submits that in this particular case, equally, Your Honors cannot reasonably come to the conclusion, particularly as more information was provided by the first respondent in this matter than the first defendant. Turning now briefly to this issue of the the COTED decision being disproportionate because there was a quota of which COTED was not aware. Well, first, if COTED was not aware of it, that mere fact that a member state needs to take additional measures to deal with supporting local industry or the economy, that would not render the decision ultra virus. So the submission of the second respondent, therefore, is that the factual and legal grounds cited by my learned friend do not establish a prima facie case of success on the trial of the originating application, if I use the words of your honors in the 2018 TCL case.
But Mrs. Bob-Schaefer, you have not objected to special leave, have you?
Well, your honors, I need to turn to that, because if your honors do find, after now we have the research, and now after the Caribbean community has had sight of the interventions of the submissions of my learned friend, and now the Caribbean community is of the view that no prima facie right has been established, and therefore the applicants cannot, if your honors come to the same conclusion, satisfy the criteria under paragraph B of Article 222 of the revised Treaty of Chagaramas.
Well, that's precisely my point, because
yes,
it seems to me that you have already conceded that ground, haven't you? And so has the state of Trinidad.
But your honors, that was before. But your honors, this is a court of justice, and the fact that I may have said something doesn't necessarily make it mean that the court does not have the power. If the court comes to the conclusion that no prima facie, can you hear me now?
Yes, we can hear you now. Yeah, thank you.
Right, okay. So if your honors come to the conclusion that the applicants have not established a prima facie breach of rights under community law that would entitle them to have the COTED decision quashed, then equally your honors ought not to come to the conclusion that the applicants have established that they have been prejudiced in respect of the enjoyment of the right or benefit mentioned in paragraph A of Article 222.
Yes, we're on the same page, and I'm just trying to make sure we can reach each other. Now, I thought that both respondents had indicated to the court that they had no objection to the grant of special leave. The grant of special leave entails that the applicants have established a prima facie case for trial. So I am just curious as to how you are squaring that commitment given to the court with what you're now saying, and I suspect the same question could be directed at Mrs. Speak. You seem to be now saying something a little different from what you had said in your written commitments to the court.
Yes, your honors, and this is based on having seen the submissions of my learned friend and having the opportunity to do further research. And when we did the further research revealed that there is no breach, there's no prima facie breach of rights that would entitle the applicants to the relief sought. You cannot say that they've been prejudiced. So what I may say, and I would have to concede, is that we did not do our homework at that time as well as we should, but it became very evident in preparing the response that the applicants do not have a prima facie case, and we went through every right that they alleged that they had, and they either didn't have that right or they didn't provide the facts to show that there was a breach of that right. An example of that would be in relation to improper purposes. Of course, if the court found that COTED had misused its power, the court could have, declared the decision ultra-virus. So they have a right in terms of saying a right to ensure that COTED's power is not misused. But the difficulty in this case is that the evidence doesn't support a breach of that right. So,
yes,
so
well, I think you've introduced a very interesting argument. Thank you.
Okay.
Yes.
So Your Honor, so I dealt with consultation. Oh, I'd like to deal with the WTO issue. So my learned friends have submitted that the COTED's decision was unlawful in that COTED had no regard to the applicant's entitlement to the protections provided by the WTO. Since when, Your Honors? Since when, Your Honors, must COTED have regard to the applicant's entitlement to protections under the WTO? The jurisprudence is clear, and this is not law that was decided yesterday. We have clear jurisprudence from the European Court of Justice since 1999, and that was not the first case because there's also the International Fruit and Banana case, but in Portuguese Republic and the Council of the European Union, on page 580 of my submissions, I've pointed out that the European Court of Justice said, having regard to their nature and structure, the WTO agreements are not in principle among the rules in the light of which the court is to review the legality of measures adopted by the community institutions. And they give two exceptions which are relevant here.
Mrs. Bob Schiffer, was that a case on interim measures?
It's not a case on interim measures, it's a case with law that is relevant to this. This is what we're taking from here is not whether there was irreparable harm or whether there was an undertaking. What we're taking from this case is what is the law that deals with whether a court should review the legality of measures adopted by the community organs, by CARICOM's community organs. What is the rule of law in relation to the WTO agreements? What does the law state?
Now, Dr. Bob Schiffer, I've seen those decisions. It's very interesting that the European Union doesn't bother too much with the obligations from general international law, and actually the European Court has been criticized about that. Now, they might be right, they might be wrong, but anyway, that is still an issue that is not purely solved by citing decisions of the European Court. So it is still an interesting matter. To what extent? And I'm not saying at all that that it must have an impact on CARICOM law, but there is an interlock between the WTO system and CARICOM. We know that CARICOM is a regional trade agreement, so a kind of oasis in the bad world of the WTO, so to speak. But the question is then, suppose, and that is not at all clear yet, but suppose that it is absolutely clear to COTED that, for example, Trinidad has a bound rate of 5% for this kind of cement. Suppose that that is clear. I'm not saying it is. So what does COTED say then? Okay, well, yeah, that's something we don't look at. That has nothing to do with CARICOM, and so we ignore that. I put it a little strongly, but just to get your view on that issue, does it really has no impact whatsoever? Mr. Benjamin referred to this issue with Haiti in 2015. Now you could say, well, yeah, well, on that occasion, COTED took regard of that, but the question is more: are you obligated? Do you have a duty under international law to take that into account? So how do you look at that?
Your Honors, I would say there is no duty to take that into account, because when you understand the operation of, as your Honors do, the operation of the WTO and the dispute settlement body, and that the dispute settlement body is the exclusive forum to determine whether a member state is in breach. But this is not the position here, because in the notification which Trinidad and Tobago brought to the attention of COTED in 2019, they informed COTED that they had received a communication, that they had notified the WTO on the, and this communication is dated, this is dated, well, they said the notification says that it was received on the 12th of November 2019. But in the notification, what Trinidad and Tobago did said that it had modified its bound rate. So Trinidad and Tobago's bound rate on other hydraulic cement is 70%. The dispute settlement body has not come back and say that the measure is inconsistent, or the measure is still inconsistent, you should not have gone under this paragraph, etc. None of that. And the only person who can determine whether Trinidad's bond rate is legally 70%, as they modified it, not going to modify it, they've already modified it. If your honors look at page 245 of the record, where Trinidad and Tobago notified the modification of their WTO rules. But even if the DSU, the DSB, the dispute settlement body, even if the dispute settlement body came to the conclusion that the measure was inconsistent, that's not the end of the matter. Trinidad and Tobago can provide compensation, and that is why the European Court of Justice looked and saw the flexibility that exists in the rules. So Trinidad and Tobago could offer compensation to the affected member state, and that's the end of the matter. But what by submission is, notwithstanding, Trinidad and Tobago has modified its bound rate, the DSU has not, sorry, I keep saying DSU, the DSB, the dispute settlement body, has not declared the measure to be inconsistent. Notwithstanding all of that, the jurisprudence is, and this has to do with the very nature of the rules, the sort of issues that I've raised, that it is not for the court to review the legality of community measures in light of the WTO agreements. It's a special thing, it is not the end of the matter. It's not the end of the matter. It's not for the applicants to say your measure is inconsistent with the WTO. It's not even for COTED to say that, because once Trinidad and Tobago indicated that it had modified its bound rate, the only person that could say otherwise is the DSB.
Okay, you have seen the expert statement of Mr. Nicely?
Yes, I've seen Mr. Nicely. Mr. Nicely, he submitted his legal opinion is that they could not have gone under Article 18, Section C, Article 18 of the GATT. That's what he has said. Mm-hmm. But remember, as your honors know, the TSB is the only body that can say is inconsistent. In the case cited by my learned friend from TCL, page 1125 of the record, he refers to the case of Canada continued suspension at paragraph 371. And he said, the appellate body has explained Article 23.1 lays down the fundamental obligation of WTO members to have recourse to the rules and procedures of the DSU when seeking redress of violation of the covered agreements. Article 23 restricts WTO members' conduct in two respects. First, Article 23.1, paragraph 1 for Article 23, established the WTO settlement regime as the exclusive forum for the resolution of such disputes and requires adherence to the rules of the DSU, dispute settlement understanding. Then it goes secondly, and this is important, your honors, secondly, Article 23.2 prohibits certain unilateral action by a WTO member. Thus, a member cannot unilaterally determine that a violation has occurred. Benefits have been nullified or impaired, or that the attainment of any objective of the covered agreements has been impeded. So if a WTO member cannot just unilaterally do that, if they can't do that, how should COTED, sitting as COTED, determine that Trinidad and Tobago is in breach? So Your Honor, so with respect, we say once Your Honors apply the law, the jurisprudence in the Canada continued suspension case cited by my learned friend from TCL, as well as the cases of Portuguese Republic, Council of the European Union, Queen Secretary of State for Health, and there are others. It's not just one random case. Even in the Queen's case, what the court said something about, listen, the court has consistently held that the lawfulness of a community measure cannot be assessed in the light of instruments of international law, which, like the WTO and the TRIPS agreement, which is part of it, are not in principle having regard to the nature and structure, that sort of flexibility, among the rules in the light of which the court is to review the lawfulness of measures adopted by the community institutions. And we say, Your Honor, that is the law that should be applied here at the hearing of the application for interim measures, and the law that should be applied at the trial. But I don't even think, Your Honor, with respect, that we need to go to a trial, because once Your Honor is satisfied.
Mrs. Babshafer, let's deal with this one first, please. Let's not. But the point is this: I thought that Mr. Benjamin very deftly tried to get out of the difficulty you're describing by having recourse to customer international law. Did you not hear him say that there was a practice which had developed in customer international law, which could be taken cognizance of by tribunals other than the DSB and so on?
Your Honors, even if such a principle exists in customary international law, we have jurisprudence from the European Court of Justice, which is directly on point, dealing with WTO agreements and not international obligations in general and international agreements in general. So I would say that more weight, if the court had to determine what to apply, that more weight should be given to the jurisprudence of the European Court of Justice. Your Honors, COTED now, the ministers come, the trade ministers come, and before the trade ministers now can make a decision, they now have to say, bring me all your agreement, all your international agreements that you've entered into. Let me send it to the LAC and see if there's been compliance with your international obligations.
Mrs. Schaefer, I think we get the point, but of course, if that is a legal obligation, I'm sure you'd assist them in fulfilling it, would you not?
Well, it is not illegal.
Yes, but we don't want to beg the question. But I'm saying if that was the case, then I'm sure you would discharge your duties according to law, would you not?
But business would stop.
Yes. I take your point. I take your point. I understand what you're saying.
Well, thank you. Okay, Your Honors. So I dealt with the WTO issue in relation to improper purposes. I touched on that, indicating that the applicant, you can't just simply assert. This is a very serious allegation. To be saying that COTED acted for the purposes of eliminating trade with Turkey. It is a very serious allegation, and if my friend is going to make such a serious allegation, he needs to adhere to the law and bring the objective evidence. He cannot just say that and expect the court to say there's a prima facie establishment of rights. I will now like to turn to the last matter, and that is the issue of whether, so it's just assuming that all the conditions were satisfied, which we say they haven't been, but just assuming that they were satisfied, we know that it's open to the court, nevertheless, not to grant the application for interim measures if the court is of the view that it would be unjust to do so. And the Caribbean community submits that it would be unjust to do so. Putting $45,000 in an escrow account does not stop the flood of cement products. It does not stop the applicants from dominating and taking over the market share of TCL. It does not stop TCL from being forced almost to close down.
This is the problem I'm having, the same problem I had with Senior Counsel Jeremy. So if the money goes into the escrow account that the president mentioned, you're saying, all of these terrible consequences will follow. But if the 45% goes into the Ministry of Finance, for want of better words, then these consequences will not follow. This is what is bothering me. I'm not sure I'm following that argument at all.
But what are the applicants?
Right.
The applicants could have a loan, so they could get a loan, and they could say, this is just a temporary measure, and they put the money in the escrow account. Meanwhile, the money is in the escrow account. They don't pass on the cost to the consumer. They don't pass on the cost to the consumer. So if they don't pass on the cost to the consumer, their products remain far more competitive than those of TCL, with the result that they would garner a greater market share in the cement industry than TCL. They could say, for the purposes of case, we're going to do this, and they can import a lot of cement. They don't pass it on to the consumer, and they cause TCL irreparable harm. Irreparable harm. This is more than just money. This has to do with jobs. This has to do with other contracts entered into. And Your Honor, this has just brought me to a very, very important point. Your Honor has raised the question of notice. These, importers of extra-regional cement require notice. I would say, as the European Court of Justice did in Portuguese Republic and the Council of the European Union, it is settled law that the principle for respect for legitimate expectations cannot be used to make a regulation unalterable, and I would extend it to say to prevent COTED from suspending the CET to impose a higher tariff.
Can we pause there? You use the word unalterable. I honestly didn't think that is what I was suggesting or asking, because I'm not suggesting anything really. It is simply a matter of some lead time to absorb the new regulation into the business arrangement. It is not saying that the law, the tax, whatever it is, cannot be changed. So I'm not sure that what you're going to go on to quote is going to respond to the issue I was raising.
So let me try to do better. So Your Honors, if there was a significant lead time, then it defeats the purpose of the CET being responsive to changes in the economic environment. Mm-hmm. Because a member state would say, okay, the industry is suffering, but I can't do anything. I have to let the importers of extra-regional cement who fully well know that the aim of the treaty, one of the aims is to protect regional production, and who with all that knowledge deliberately entered into contracts and then come to use that as a defense. That cannot be a defense in law. That cannot be a defense. I think the governing principle is that it is reasonably foreseeable that the importers know that there would be a continuous adjustment of the tariffs on cement in response to changes in the economic situation. They know that, and they need to know that.
Just to support that trend of thought. So if for example, the investor was a foreign investor, somebody outside the region came into, let us say, Trinidad to do business, then I presume that foreign investor would be susceptible to governmental regulations. And that investor could not say, well, look, I came in here to do this and you have changed the law on me. They have to take the situation as they find it. Is that essentially, I suppose the foreign investor would be protected. Usually they're protected by some foreign investment treaty or something like that. But
Right, yes.
outside of that, you're saying that you take it as anybody else would.
Yes, yes. You would have to look. I wouldn't say that you would ignore the BIT, the bilateral investment treaty. I wouldn't say you. I mean, you would have to look at that.
No, that's what I'm saying. So no, yeah, I think we're on the same page. So if you're protected by the BIT, then you get that protection.
Yes.
But if you are not so protected, then you are at the discretion of the government.
As all community nationals are. And I do absolutely support the interventions of Trinidad and Tobago,
So in some respects, then, the foreign investor who comes in under the wings of a BIT is in a better position than an indigenous company which seeks to engage in extra-regional trade.
Your Honor, I cannot say that without actually realizing it, checking to see if that is indeed fact.
No, but that follows from what you're saying. You're saying that the foreign investor would benefit from the protections of the bilateral trade investment agreement.
Your Honor, that's just speculation. I have to do research to be able to tell you that definitively. What I can say definitively is that economic operators, and there are other EU cases that I've seen when preparing for the other case, that economic operators must take into account that there will be an adjustment of tariffs to deal with economic situations. You can't go and enter into a contract and then come to the court and tell the court.
But there are many cases where the foreign investor in that kind of situation, being a beneficiary of protection of the treaty we just spoke about, do have resort to the International Center for Settlement of Investment Disputes, ICSID. So I'm just mentioning that because that might be something that CARICOM might wish to consider going forward. But I don't wish to detain you much further. And you did say 15 minutes, and I don't know how far you are in that program of yours.
I'm at the 13th minute. So if I could just have 2 more of the 15 minutes.
Okay, so you need 2 more minutes, Dr. Buckley.
No, this is literally 2 minutes. Literally 2 minutes.
That is very good.
Okay, so it's just to deal with a issue of it being just Your Honors. I'm not saying that because I'm a lawyer for the community, but I urge your Honors to look at the facts of this case in light of the fact that the treaty is intended to protect and encourage regional producing. So I would just urge your Honors to consider. I'm just looking for the correct page. Oh, they're pages. So pages. Yes, I see it now. So pages 585 and 586 of the record, where I've outlined a number of facts which indicate that other than hydraulic cement is competing with the cement produced by TCL. And I like the use of the language by your Honor. The Caribbean community carries a view of the sea, and the way, see, they have internet problems. Yeah, but the way in which the Caribbean community is still seeking to provide that protection is through authorizations to suspend the CET. And if TCL, who has a legitimate expectation to be protected, is not protected, it opens up the Caribbean community to liability. But that's not the true real injustice. Although that's unjust, I think the real focus should be on TCL, that they have a legitimate expectation on persons who could have foreseen, for whom it was reasonably foreseeable that there was an adjustment in the tariff, will come to the CCJ time and time again, asking the court for relief to allow it to act in a way that places TCL in a very difficult financial position. So in essence, just to sum up, the submissions of the Caribbean community are that one, there's no prima facie breach of rights under community law that would entitle the applicant to this temporary of the COTED decision. And two, it would be unjust to grant the applicants who have no legitimate expectation, that the tariff would remain the same or that COTED would not authorize member states to suspend the CET. So it'd be unjust in these instances to grant the application of the applicants. And we'd ask that the application be dismissed with cause, and that in turning your attention, Your Honors, to the question of special leave, the Caribbean community says that if the court finds that the applicants have not established a prima facie breach of rights entitling them to this temporary quashing of the COTED decision, then the court may also find that the criteria for special leave, and in this instance, I'm referring to paragraph B of Article 222, have not been met. Those are my submissions, Your Honors.
Thank you very much.
Your Honors, might I just have 1 minute? And this is in response to Justice Anderson's query with respect to my formulation. Just 1 minute.
Yes, 1 minute.
I'm reclaiming my time because I was very brief. Justice Anderson said that he had some difficulty with understanding my acceptance of a proposition. And the more that I think of it, is the more that I think that I am right. So I would like just an opportunity to convince him. Mm-hmm. See, if I am a producer of cement, and it is the case that a producer who is outside of the region is producing cement at a rate which is, for want of a better word, it's coming into the region at grossly deflated prices. Mm-hmm. Tariff, which carries that product up to the equivalent of my production cost, is going to allow me to survive. That's the only point that I wish to make. And if your lordship, if your honors impose a condition which says you place that percentage into an escrow account. Escrow means it is beyond the reach of.
Sure.
So if it is beyond the reach of until trial, then I can carry on business on a level playing field with respect to the person who is bringing in cement. I've checked this with my client, so I'm not speaking alone on this. This is not. Now, having said so, I understand and I align myself with the position of the Trinidad government, which has, in this limited respect, certain different considerations, sure, which are articulated by my learned colleague. The government's position is a serious position, and it sounds in revenue, the collection of revenue, and the government is going to wish to be able to hold on to the revenues, which on the facts, and I agree with the contention by Millennium Friend, it is entitled to, because Millennium Friend does not cross the threshold. But if your lordships think, in the event that your lordships think that they have crossed the threshold, then if you we can live with a position which allows us to survive. And I'm talking about survival for us. I'm not talking about survival for the government, which is a different thing.
Yeah. Thank you.
I have explained it.
I think you're
thank you very much, Senior. Thank you. Yes.
Very clear. Okay, we can return to Mr. Benjamin. Of course, it's quite late, but I'm sure you are not going to take too much time.
No. But Your Honor, I'm entirely in your hands. There is a lot to respond to, but I did not intend to be lengthy. I know I made such a rash promise at the beginning, but I'll try to respond in a fair way to the points that have been made against me.
Sure.
To see, so and by all means, you'll stop me at any point as you
I wonder, Mr. Benjamin. Yes. I know you're so flexible, so I can make this suggestion to you that you could start where Dr. Bob Schaefer left off, because I think she took us into very deep waters, and I rather suspect that Mrs. Peake might also wish an opportunity to comment. As I understand it, Mrs. Bob Schaefer is saying that as far as she is concerned, she meaning the community is concerned, you have not made out a prima facie case in respect of the arguments you have put forward, whether related to the WTO consultations or the vires of the decision. And she's saying further, and this is where I'm interested in getting your views, that if the court is so satisfied, then not only do we dismiss this application for interim measures, but there's no real basis for us to go forward in granting special leave or in indeed having a substantive trial. And I wonder, and I know this might be catching you a little bit off guard, but as I said, I have great faith in your flexibility. I wonder whether that is not an unassailable argument, because to the extent that the court finds, if it were to so find, that you have not established a prima facie case, then is there any basis for going forward?
So if you can, I can respond in this way. The way that I read your jurisprudence on special leave decisions, that is to say, I'm leafing through because I didn't expect to have to deal with this. And it's not in your bundle, so I apologize.
Sure.
Because I did have the written letters and communication from my learned friends. It seems to me, so the case that I'm looking at, and this is your jurisprudence, it's TCL Guyana against the Republic of Guyana, 2009 CCJ1. So it's part of that series of TCL cases. So does my lady, does Jocelyn have it? 2009 CCJ1.
Yes.
And if I could just invite your attention to paragraph, I think that this is 33 and then 43. So 33 first. In order to institute a claim before the court, applicants or persons, as Article 222 refers to them, must satisfy two conditions. A, that the treaty intended that a right or benefit. So just pausing there, my learned friend, Dr. Bob Schaefer, who knows a great deal about these things, focused exclusively on right. She didn't take you to the language of 222, and she didn't take you to the language of benefit. But it's a right or benefit. And I would go further because I want to be very upfront with you. I have made a number of submissions where I invite the court to move its jurisprudence forward. So insofar as I have been met with where this didn't happen in Barbados and this didn't happen in the Barbados case and there was different consultation, I say with great respect, that is an abdication. It's an invitation to abdicate the judicial function. It's not a rubber stamping that this is like the jurisprudence of this court is very clear that you decide the case that comes before you. And it's not a question of, well, it's similar to Barbados and that's the answer. That's box ticking. That's not juridical analysis with the greatest of respect. And I don't invite the court to do that. So let me continue. At paragraph 33. So it's a right or benefit conferred by or under this treaty on a contracting party, which shall inure to the benefit of such persons directly. Now, each of the applicants, because I want to focus on this, each of the applicants is an importer into CARICOM. That's what the application says, the special leave application. Paragraph 3 says the first applicant is an importer of hydraulic cement into the state of St. Lucia and the CARICOM community for redistribution or sale, and the list of CARICOM countries are given. Paragraph 4.
Sorry, Mr. Benjamin, I really apologize because I know I invited you down this road and you might not be quite ready to go down it, and I'm not sure necessarily we have to. I'm just asking a more conceptual question. And the conceptual question is this. If, and it's a big if because, you know, we have not deliberated, we have not decided, but if we came to the position that you had not established a prima facie case, right?
Would I be out?
Yes.
The answer is no.
The
answer is no. That's not what paragraph 33
says. Could you say why? Yeah.
Yes. Paragraph 33 sets out a different test. It's an arguable case that each of the conditions can be met. So that's what I was going to go on to read.
Oh, okay, no, I don't.
And I know you don't have it, and I apologize that I'm reading out material to you.
No, that's fine. I think we're familiar.
So that if you simply have in you have in your mind, so these are different tests, different language. All I have to do. So let me take the point that is, I think, the most challenging, the most interesting, with great respect, intellectually, which is the point about the WTO obligation.
Yeah.
All I wish to say to this court is that my case there is arguable. And with the great respect to my little friends who have gone to the EU, this is not the EU. We have an entirely different system. And the very Portuguese case that my little friends cites makes a very clear exception. So in fact, I'm not going to take you to the passage. At paragraphs 37 to 42, I think it is, the Portuguese case makes an exception to the exclusion. My little friend, Dr. Barb Schaefer, who, and she knows I have the highest regard for her, did not take you to that paragraph. So I say with the greatest respect that even on my most challenging point in relation to how the COTED should treat with, as a matter of the observance of the rule of law, and I need to say those words again, the rule of law, as to how it conducts its business, then I say with the greatest respect, it is bound to have regard to the illegality or the unlawfulness of the invocation of a WTO retraction of the boundary. So that's what I say with you. And I say that's arguable. I do not say with the greatest respect to each of you that I'm right. I don't say that. I say that my case is arguable, and I say that I crossed the threshold on the most challenging point in this case.
Yes.
And I say with the greatest respect that none of the plethora of cases from everywhere else should be determinative at this stage.
Okay, now I hear you, and you know, I am entirely in the hands of our chairman as to whether he wishes to have Mrs. P comment at some point, hopefully not too long from now, on this. I would only say this though, that in terms of our interpretation of Article 222, relating to the standing of private entities, we did say that one of the conditions, and they're all of course cumulative, so they all must be satisfied. One of the conditions was that the applicant must establish a prima facie case that their rights, you know, have been prejudiced along the lines that Dr. Barb Schaefer was mentioning. And in relation to that particular criterion, I was a little bit concerned, and I raised the question with her, but she was obviously prepared for it, as to how that relates to the standards we have set for the grant of interim measures. And that was part of the issue I had in mind when I was wondering about whether we're not going too deeply into the merits of the case in discussing the request for interim measures. But I'm not sure we can go too much further on that. Thank you for responding. I presume you hear about the things to speak of.
Yes, I do. Yes, I do. A great deal of what's been said by my learned friends has been, with the greatest respect to them, a mischaracterization of the case that we've sought to advance in the originating application in draft form. There is nothing in our case and there is no paragraph that can be pointed to that substantiates the imputation made against the applicants that they have gone into business on the legitimate expectation that nothing will change. That is not our case at all. Our case is a rule of law procedural case that respects the policy space that is quite properly reserved for sovereign nations and properly reserved for COTED. All that we ask is that the court hold COTED and the sovereign state of Trinidad and Tobago to the highest standards of legal conduct consistent with the principle of the rule of law. That requires transparency, that requires efficiency, that requires them to be forthright and to be forthcoming. And so without repeating anything that I've said about consultation, in answer to what my learned friends have said about the lack of notice, we say that the lack of notice is the antithesis of transparency, is the antithesis of being forthright, and it's completely inconsistent with the jurisprudence of the court, which over time, from 2009 in particular to 2020, and it's no accident, with great respect, that those two sets of authorities, both of which deal with consultation, it's not a single case, both of which deal with consultation and the application in the 2020 decision of the adumbration of the consultation principles, broadly speaking, but other principles as well. And we say that insofar as we rely upon the procedures and the invitation, that the exploration of the question as to what has been done and whether it's proper is a matter quintessentially for trial, for cross-examination, for disclosure, and for this court's ultimate decision one way or the other. And so we say with great respect that we have met the Article 218 and the Rule 12 requirements. We ask the court not to accept and to reject, in fact, what has really become a mini trial. I accept my share of responsibility for taking you into a degree of detail, but that does not obviate the fact that we say we have met the threshold test set out in the case law and in this court's jurisprudence on each of the grounds and in the way that I've already articulated. Insofar as there is a suggestion that what we are actually asking for by way of interim measures is a quashing of the decision of COTED until trial, that of course is to speak in grammatical inconsistencies. If something is quashed, it's quashed. It can't be quashed until. So it will be more accurate to speak in the language of suspension, or more accurate to speak in the language of staying, because those words accurately convey juridically. I'm not making a grammatical point. I'm not trying to quibble, but only to invite the court to a greater degree of circumspection about what we are asking the court to do. We are asking for a temporary reprieve. Our evidence is that at 50%, the cement that comes into Trinidad will be sold at a price where we will lose money. And we set out our losses in our affidavit. We set out that in our, yes, we do. We set out in the affidavit. We say that we will lose money. That's what we say. Now, as it happens, we are yoked with a quota. And Mrs. Peake has been very candid to confirm to the court that the extent of the quota is not the 55,000 that I began with, but it's now 37,000 tons. So it's 37,000 tons, which is really one of these ships that comes into the jurisdiction. They have a maximum of approximately 30,000. So it's a ship and a bit. It's one shipment and a bit. And for the court to accept the hyperbolic suggestion that TCL after 65 years will fall into the sea, will be driven out of business, that we will be flooded with cement. That was and I say with great respect to Her Honor, Madam Vajrampuri, who asked the question. She asked the question, well, isn't that the mischief? And the answer to that, if I may say so, very pointed and very helpful question is no. That mischief has been completely obviated by the cumulative piling upon burdens that the state of Trinidad and Tobago has saw fit to impose on us. And of course, it has consequences for the public interest, but I'll leave that for last. And I just want to flag the public interest of the cement buying public of CARICOM, about whom not a word has been said by my learned friends. But that danger, that mischief, Your Honors, is completely gone because there is a quota. And until such time as that quota is set aside in the High Court proceedings or by another court at another level, then that quota is what binds us. So there is no danger. And that is why my little friend, Mrs. Peake, was very careful to identify 2 shipments. My evidence was speaking really to the February shipment, but she did her mathematics and it's a shipment plus. So if that 37 is divided into 2, it's 17 and a half, 18 and a half, I don't know. But my point is that there is no basis and there was nothing in the evidence or in the very, how should I say, impassioned submissions made by my learned friends on the other side that changes those objective facts. So it's very, very helpful, I think, with respect. When the court is coming to consider what would be a matter of making the justice of the case, the uncontradicted evidence that we have put before the court is that over the entire period of time that we have been in the cement importation business, and when I say we, I mean all 3 applicants, I want to make that very clear, that the cement buying public has benefited. And it has benefited from inexpensive. We have located inexpensive cement from another part of the world, and we have introduced it into the market. And that brought the price down. The evidence is that it came down in 2016. So the TCL's price, as any good competitive entity would, and that is entirely consistent with the objectives and the language of the RTC. Yes, Mrs. Speaker is perfectly right to say that a part of the RTC is about facilitating production, but she is wrong to exclude facilitating production. My lady, I'm sorry, should I stop? There is
no, go on.
No, there's a message. I didn't know whether it was meant for me. But she is wrong to exclude from her invitation to the court the fact that the purpose of that protection is to develop robust players who can survive on the international market. Does anyone doubt, and I will take a little poke at my little friend, Mrs. Peake. Does anyone doubt that Mrs. Peake can stand toe-to-toe with our colleagues in any other part of the English-speaking Commonwealth? That is because she has been strengthened by the practice of law over a period of time, and that is what is expected of TCL, and that is what the RTC provides.
Mr. Benjamin, we are all very mesmerized by your very impassioned delivery. The difficulty, sir, is that I'm not sure this is necessarily the forum for it. I think there are lots of very good fora where those arguments could be made, but I am not sure we are in a position to evaluate the sort of economic benefits and counter benefits, etc.
Yeah. Your Honor, Judge Anderson, I was only responding to the suggestion that it was unjust, and each of the defense respondents' counsel have in different ways suggested that it would be unjust, and that in TCL's case they say they would collapse. We say that the evidence does not support such a suggestion, precisely for the reason that I've already given, and nothing that I said about the price of cement is contradicted, because that, over the period of time that I've set out, because that's in our evidence. No one contradicted it. There are affidavits in answer from all of my learned friends except CARICOM, and that's accepted. And as a matter of fact, among the background that was relied upon in the application, that is set out.
Mr. Benjamin,
yes.
I appreciate that you are trying to cement your case, so to speak, but
trying to get to the end.
Yeah, and I have a very, very concrete question too. Actually. Yes. One of the things that you have to show is that we all understand that this measure will harm your clients.
Yes.
The question is it an irreparable harm of an irreparable nature? Will it wipe you off the face of Trinidad and Tobago?
Yes.
Because as you were saying, we have to accept the reality for the time being that there is a quota, so that maybe one and a little bit shipment could come in, and that would be it. So if it is that the 50% stands and there is no interim measure, would that, for those 2 shipments alone, wipe your clients of the face of the earth, or isn't that bad? Because that you will be harmed is clear, it seems to me, because you have to pay much more than you used to pay. So that is one question. And then the other question is, because you have said, well, we offer an undertaking to indemnify the state. Well, I gave one example, which was discussed, but there are many examples how to do that. But if, for example, we would say, yes, we agree with you, but we ask you to put the difference into a escrow, well, then you would be still paying 50%, but the only thing is that you would be paying, for the time being, you would pay an amount, well, to a neutral kind of account, but not to the government. But if you lose, that money will go to the to the state. So if you could react on those kind of practical issues here.
Yes, could I take the second one first, if I may? Yes. So if I am to be called upon to pay out what we say is a disproportionate and punishing level of duty, it in effect makes my cement unsellable. So it means I would have paid for a good. I would have paid a much higher level of duty than I was paying a year or 2 ago. I have over the previous 12 months absorbed 35%, which must mean that I'm a good corporate citizen because I would have made less profit. That's the logic of it.
Yes.
Right? That's the logic of it. If I then, on top of what happened over the last 12 months, have to absorb an additional 15% above the 35%, so I've absorbed the 35%, I now have to, and then, so I can't sell my cement at a price that allows me to recover. And therefore I'm out of the cement business, and I have cement that that can only be sold or gotten rid of or dumped because it's unsellable. And that the evidence that we put in the affidavit, and it's supported by what's in the documents, is that it's at a price, at 50% is at a price it can't be. And the evidence also is, we, in our response to these circumstances, closed our doors for 1 month. So we were completely closed for the whole of January, right? We went to the marketplace. The shipment came in on the 23rd, and that cement, there have been sales, but they have been minuscule. I know I'm giving evidence. These are my instructions. So you asked me about, but practically speaking, forget what I said about the sale of cement. Practically speaking, it's unsellable because of in realistic terms, the total price that we have paid. To answer your question about where the money goes, once the money leaves our account, it doesn't really matter to whom it goes, right? It's already had, it would have had immediately its adverse financial impact. It's not going to make a difference whether it's paid to the exchequer or whether it's paid into an escrow account from a financial point of view, but much more importantly, from a business point of view. And to answer your direct question about what happens to us as a business, it is the importation business, not the construction business. It's the importation business, which is at an end, effectively. Oh.
Okay.
Sorry. I have a small technical problem that just came up, so I had to deal with it. So that is my respectful answer to your Honor's question.
Great. Is there anything else you want to remark?
Well, that might be a dangerous question, Chairman.
Your Honors, I have not. I appreciate that you've been very patient, and I haven't been able to respond to all of the many points made by my 3 colleagues. But I think that you are going to take everything that is on the written documents into account. And it's 6 o'clock. I didn't propose to detain you any further. I'm of course prepared to answer any question that the panel wishes to put to me.
I don't think we will be so brave to ask any further questions.
No. But I think with your leave, Chairman, I wondered if Mrs. Speak wanted to take 2 minutes to say anything in relation to what has been said.
Well,
Your Honor, I think it is in relation to the question as to whether the test under Article 222 has been satisfied. Is that the intervention? Frankly, we have not focused on that. And respectfully, I don't think that we should enter into that arena at this stage. I think we should focus on the test to be satisfied for the grant of interim measures. What we had said, but in writing, you will recall by letter the 1st of February, is that we would have agreed not to object to the application expressly without prejudice to the contention that the proposed claim is without merit. So we made it clear that we were not conceding that they had established, a case that is worthy of consideration by the court. But I think we can easily get sidetracked if we try to go down the road of what might be a different test, in determining this application. But I do accept that there would be a knock-on effect once the court takes the view that we have advanced that they have not established a prima facie case of success. But I prefer to take it in bits rather than trying to deal with that at this stage.
Okay, thank you.
I think that is a very sensible position. Maybe what we can do, we would want to withdraw just for a few minutes to see if we can give you an idea when we will be able to give you a decision in this particular matter, and then of course after that we'll see how things go. So if you just wait for a few minutes, then we will withdraw in our virtual deliberation room, and we will be back within a few minutes to give you an idea when we intend to give a decision. Yes, Madam Deputy, we're all here.
Yes, Judge, I'm seeing counsel for all the parties represented, so you can proceed. Thank you.
Thank you. Okay, we will deliver a decision on the 19th, Friday, 19th of February at 2 p.m. Friday, the 19th of February at 2 p.m. And well, depending on that, what that decision is, we will see if something has to happen next, and if so, what. We will discuss that with all the parties. Thank you very much, Madam Deputy. You can close out.
Your Honors. Most grateful.
Thank you, Honourable Mr. Justice Witt. Thank you, Honourable Mr. Justice Anderson and Madam Justice George Nutley. Counsel, thank you. And of course, our staff at the Caribbean Court of Justice, thank you. This court now stands adjourned. Good evening and safety to all. Thank you. Bye-bye.
Thank you very much.